What is the urgency? Motion. Eh? Huh? Oh. What do you mention again? Item number 153. Not this week. Okay, which is called then mention.
No, সব যা আছে জিনিস শুদ্ধ আছে।
This way. Okay, let the monthly list be published, then you mention. It would be.
Mention item number 195 of the today's list, my lord. It's extremely urgent. That, Lord, a 20 years experience of headmaster is illegally suspended by the board, my lord, when the matter is sub judice. And
Item number?
item 195, my lord, will return in December 2025. As fixed matter, my lord.
Okay, upgrade coordinator. Upgraded matter. It will under.
May I be permitted to mention, my lord, that the passport matters, kindly remember.
Yes, yes.
My lord, that is fixed on 8th
8.
morning. My lord, I have a very, my lord, 2 days, 8th and 9th, I will not be here. My lord, I have brought the passports for your lordship's perusal, my lord. Your lordship can kindly accommodate me, my lord, for 8th and 9th. Kindly keep it on 10th, I have no difficulty.
Then which the other side?
But I have given the notice.
You are the other side. So I'm fixing out 10.
And will kindly see the passports or with the seal cover
Okay.
to satisfy your lordship.
At that time?
Okay, but I am satisfied it is in this.
Okay, at that time. So you matter give your list, otherwise give your slip. এই শুনুন এই ম্যাটারটা 8 তারিখে ফিক্স আছে ওটা আপনি 10 তারিখে 10 তারিখে লিখে রেখে দিন
ঠিক
May I be permitted to mention what?
I have already given notice to the other side.
Yes, you mentioned this matter 195. Yes, it should be upgraded. Don't.
Upgrade list, my lord. Kindly fix the matter.
No, not in this way. Every matter cannot be fixed. It will appear under the heading upgraded matter.
I am telling your lordship that this matter, my lord, was heard before Honorable Justice Parthasarathi Sen, lord. Thereafter, I challenge that order of division bench. Division bench given a direction that, my lord, if the pendency of proceeding is void ab initio and there has been a breach of natural justice as the inquiry stage, the entire proceeding can be quashed by the learned single judge, which is possible only after the full facts are disclosed before the learned single judge. So, my lord, this is nothing, my lord. Simply, my lord.
There is no direction that learned single judge is to give priority over all the matters. It is not. It will appear under the heading upgraded matter, and you keep yourself ready because the matter will be supple and any day it would be taken up. Okay, you hand over the slip.
My lord, may I be permitted to mention, my lord, one hearing matter, my lord. 2018, my lord, petitioner, my lord, getting pension, my lord, at a lower rate, my lord, 70 years old, my lord, lady, my lord.
What are you doing for last 7 years?
Several times, my lord, I have mentioned, my lord. That's why, my lord, again, my learned friend, if appeared, my lord, then
Okay, monthly list of July.
But may I be permitted to mention?
To the other side, my lord, I'm mentioning this matter, my lord, item number 332 of the
Item number?
332 of the monthly combined list, my lord, for upgradation, my lord.
May I suggest one thing? Let the monthly list publish. Thereafter, you mention for upgradation. Okay, that would be better. Okay, your matter is already in the list. Okay, Okay, it will remain in the list.
My lord, may I be permitted to mention, my lord, item 116 of my lord's daily list, my lord. My lord, there's urgency in the matter, my lord, in the sense, my lord, my client, my lord, the petitioner is a student of an MTech course. The university has cancelled his registration, my lord, in the middle of his course without granting any opportunity of hearing. My lord, there's been directions for filing of affidavits. Affidavits are complete. It's a hearing matter, my lord. Only point is natural justice violation, my lord. It will take me 5 minutes only to place the case, my lord. My lord, I apologize, my lord, will
All
kindly
matters
my lord, will
will
kindly
take while.
appreciate that my client will lose out an academic year. He's a student, my lord, of an MTech course of Knockout University, my lord. He'll lose out an academic year.
When you file this matter,
My lord, we filed it
item
November
number?
116 of the daily list. November 2024 was the impugned decision. We filed it in December. Immediately, within a few weeks.
Okay, the upgraded matter হিসাবে upgraded.
Deeply obliged. Deeply,
Upgraded, এটা upgraded.
deeply
But
obliged.
only for inclusive.
It's an assigned matter, my lord. Your lordship has passed an order on 9th April. Thereafter, 2 weeks hence, the matter to be listed. Not yet listed.
Civil
My lord,
matter,
yes. My lord. This is a
civil division.
civil division matter, my lord. Your lordship passed an order on 9th April.
আচ্ছা অ্যাসাইন ম্যাটারটা দেখে নিন তো
But may I have my lord's leave to mention, my lord?
লেট দ্য লাইন বি
Order
কমপ্লিট
is enclosed.
ইয়েস
My lord, this is for my lord inclusion in the list, my lord.
what is the urgency? Tell, there are many matters.
Suspended from his job, my lord. The last 1 year, he has not received a single paisa subsistence allowance.
Monthly list take July.
Actually, monthly, my lord.
হ্যাঁ
The cooperative group by manager, and the meeting hearing, this matter is a covered matter. Why, your lordship has passed similar order in this particular bank, where the charge sheet has been issued by a board of directors who are not competent enough to issue these. This issue has already been decided, my lord. I'll carry the order, my lord. Let it be enlisted on any day, my lord, and this can be heard.
monthly list of July.
My lord, may I
Monthly list
kindly
of
be
July.
permitted to mention?
Urgency?
Yes, my lord.
Restoration application. Restoration application. Now I'm coming this side. Urgency, what is that? You give your retirement benefit matter, it's under the heading pension matter. Oh, you have brought 4 or 5 matters. Monthly list, yes. Later, let the monthly list publish. One, the pension matter is the pension matter act 1, which is a pension matter. Pension matter didi. What is the urgency? It is the only urgency. Wait for some time. You are the second line. You wait, your turn will come. Yes? Okay, pension matter, only one. Only one now, later.
So matter, when also please remember that matter one of the Indian corporation. The matter has been settled between the parties because of this.
Settled.
No, not at all. They are not interested. And on last communication, also please to allow my mentioning and directly the matter to appear again. Thanks, mention of the allowed, but the matter is not appearing. So I will again add this.
Then you give notice to other side without.
On other occasion, there will be.
No. You give notice that today that you will mention.
There is a direction by your lordship.
I know. You give notice.
I shall give notice today.
No, upon notice to the other side. Mentioning will be allowed only on Monday and Thursday upon notice to other side. Specifically mentioned. No, Mr. Hossain. No, Mr. Hossain. Allow the court to follow a rule for all. Uniformly for all. No. You give notice, then mention on Monday.
Lord, upon notice, I am mentioning, my lord, there is some urgency in this matter. There was a direction to file opposition by Justice Gaurang Kant. This is a matter against who have challenged the order passed by the Clinical Establishment Commission. There was a direction to file the opposition. They have not filed the opposition. My lord, the urgency is.
So another
I-
direction
my lord,
for
may I-
will come.
May I, my lord?
It is not ready for
May I,
hearing.
my lord?
You wait
May I,
for
may I,
some
my
time.
lord? My lord,
You wait
each
for
and
some
every day,
time.
my lord, I am receiving threats because I am challenging an order because of the negligence of the Woodlands Hospital, my lord, to withdraw the writ petition, my lord. There is a negligence on the part of the renowned hospital of this Calcutta.
Okay, monthly list of July.
But
Monthly
there
list
is
of
some
July.
urgency,
Monthly list
my lord.
of
Substitution application, my lord, in connection of the.
under the heading application. It under the heading application.
May I have, I'm mentioning on notice, my lord, I was supposed to install floodlights in public interest for Kollani Stadium. I've installed it, money not paid by Nodia Jila Parishad and Kollani municipality. My lord, I filed the writ petition, order was passed directing them to make payment because the claim is an admitted claim, but they have just refused to pay the money.
File contempt.
My lord,
My lord,
I appeal.
contempt is already pending, but the matter may be disposed of because there is no adjudication to be made on the part of the respondents.
I am
because-
also mentioning a
because-
recalling application. My lord, the order was passed behind the back of Jilla.
No,
Parishad. My lord, the order was without adjudication, without adjudication, and
several
my lord,
notices.
without adjudication.
Recalling application before that bench,
My lord, the recalling
which
application.
passed the order,
My lord, the honorable judge
but
has
not before this court.
the honorable judge is not there, my lord. The honorable judge has to transfer, my lord. So, my lord, it has to be taken up, my lord, before.
Whether that determination has been
My lord, in
given.
case of review, my lord, the determination has been assigned to a coordinate bench. But as far as recalling is concerned, my lord, subject to correction, my lord, it has to be taken up, my lord, with the court having determined.
My lord, they have filed a modification application. I don't know why is he saying
Recalling,
recalling.
my lord, it is
Because they've
recalling.
called it a
My lord,
modification
my lord,
of the
they
order.
have taken out an
They
application.
have themselves said that
Passed
it's a
in my
modification
absence,
application.
it has to
My
be
lord,
heard.
should not mislead the court, my lord.
I'm not misleading, sir. Sorry.
It said modification. That's the word used in the application.
Let it
My
be
lord,
taken up.
my lord,
Let the
let it be
application
taken
be
up.
taken up, my
Lord,
lord.
we'll make a submission.
Let the application be taken up.
But what kind of fraud is going on the part of state authorities? It's unbelievable.
Making comment on the face will not help the client.
এই ওইটা কোথায় ইয়েটা
But is your client threatening my client or what?
নিজের মধ্যে
Please.
কথা বলে লাভ আছে
Please.
let us not make past
No, yeah, you are saying that the
Like 2000
bench having determination will take up the application for modification recalling. But initially, this determination was given to a particular bench.
that subject to
The recalling or modification application of the judges who has transferred or not with us,
Subject-
their application shall be taken by the bench having determination.
I could only find my lord, the review applications my lord, in case where the
Review
judge could
application is
only review my lord, I could,
generally the court which passed the
has to be taken up
should have reviewed
on in that event my lord,
recalling modification such and such.
My
But
lord.
whether that determination is with this court,
recalling my lord, I could not find any other bench review I found for the judges who transferred or my lord, is retired my lord, for that purpose
that determination whether with
Honorable
this court,
Justice Kaushik Chanda is having determination my lord, in case of judges who got transferred or retired
yes.
only for review and contempt. I could not file for recalling
No.
or modification.
Where is the okay? You mentioned tomorrow this matter. So where is
I
this
shall,
matter?
my lord.
Monthly list? কোথায় দেখুন তো?
But my lord, my mentioning is for taking up the main matter and disposing it of.
Well,
My lord,
I
irrespective,
have filed a recalling.
his recalling is only with respect to an interim order. I'm praying lordship
in
that
my
the entire
absence.
matter may be heard out.
Against me, a contempt is lying.
Find
I will.
out that the bench having determination to take up the matter can also take recalling and
My lord,
modification.
may the main writ petition be taken up, lordship. It can be disposed of once and for all.
Until
lordship.
recalling is taken
It
up, my lord,
can
they
be
have filed a
disposed of
contempt.
once.
They have filed a contempt
My lord,
against me.
if the main writ
Huh?
petition is
They have filed a contempt
My lord,
against for non-compliance of that order, which is under the. We have
My lord,
filed an
my
application.
lord,
for
if the
recall.
main writ petition is disposed of, all interim orders merge with the
But let
final
the
order, so
application-
nothing will remain
let the
anyway.
app- my lord, let
I
the
want a
app-
final
Contempt
adjudication,
application is pending.
lordship,
Modification application pending.
for interim order, lordship.
Modification of that interlocutory order
Lordship,
that is pending.
Lordship.
Modification application
my lord,
of that interim order.
lordship.
So let it decided whether
My lord, I want the final matter to be disposed of. Lordship disposes of the matter fully, then no interim order will remain. It will all merge with the final order.
okay, let what your learned will find.
Contempt and review matters.
Contempt would be
Contempt and review matters, including applications connected thereto, arising out of the judgment and orders passed by the honorable single judges who are not available due to death, retirement, transfer, elevation.
uh,
So, my lord, only there is no mention of recalling, and I could not find any other honorable judge having determination for recalling. So, my lord, it has to be subject to correction.
no, there is another note. another note, there must be modification,
Check
recalling.
and come back
there
tomorrow.
might be,
I shall check.
tomorrow.
I shall.
Both of you are granted special leave to mention tomorrow. You consult whether this court can take
My
up.
lord, as far as the final writ is concerned, it's before your lordship. That lordship we've checked.
Mr. You
I'll
know
take-
very well
Right.
that keeping the interlocutory application pending,
Lord.
final matter cannot be disposed of.
My lord, we'll
Okay,
withdraw. My
final
lord, we'll withdraw. My lord,
petition cannot be disposed of. Every court should dispose of first the interlocutory matter, interlocutory application filed in connection with the main petition. Thereafter, the court will
My lord.
dispose of
My
the
lord,
main
that
petition.
interlocutory is in
It is.
respect of another interlocutory.
Because if the main petition is disposed of, all this application will be infectious.
Lordship, then my learned
Now-
friend may succeed. He
Now
has a better
you-
chance. He has a
you
better
want-
chance.
Let the main petition disposed
Yes,
of.
because it's a very
Let
short
all
matter.
the petition filed by the other side be infectious.
Because he'll have a better chance of winning it for a final
What
adjudication.
is that much of
My
intelligence?
lord, the interlocutory or
Power to understand your
my lord,
motto.
interlocutory is
shall
in
come back
respect of another interlocutory order. It's not in respect of any final adjudication.
Okay.
That's why it can be proceeded with lordship.
Interlocutory petition was filed in connection with the main petition.
My
My
lord.
lord, there's no interlocutory
So it
petition.
is
This
the
a writ
duty
petition,
of the
lordship.
court to first
Writ petition.
dispose of all the interlocutory application, then only to touch the main
lord.
petition.
My lord, I want to
Okay.
let go of my interim order. I want the
So
final order
let
to be
it
passed.
be
Let them
decided.
withdraw the
You
petition.
also
Let them
I'll-
withdraw
you
the
also
petition.
consult with the
Lordship will come back tomorrow. We'll come
we
back
will.
tomorrow.
We will.
not given in the monthly list.
So grateful, Maharaj.
My lord, this is a hearing matter, my lord, where the petitioners are being denied appointment because of higher qualification. Higher qualification cannot be a bar for appointment. It involves that point. It's a hearing matter, my lord. I'm just praying for inclusion in the monthly list.
Monthly list.
Old matter.
Where passed an order,
Couldn't follow.
my lord, where coordinate bench has passed an order to the Pradhan to file a report. But upon inspection of the unauthorized construction, but till no inspection has been conducted, no report has been filed. Even the unauthorized construction is going on, my lord. So, my lord,
Okay. Hearing stage it is.
my lord,
Direction for affidavit was given.
yes, my lord.
Report means it is not as it hearing matter.
My lord, it is in a stage of
Motion
no,
bench is available.
no, my lord. It is in the part of hearing only, my lord.
Whether direction for affidavit has been given. Report direction for filing report means.
Yeah.
So mention before the appropriate bench.
My lord, may I wish to mention one matter for inclusion. My lord, this matter was earlier running in the list of Honorable Justice Master Solution, but after change of determination, this went out of list. My lord, I am praying for inclusion. I have served notice upon the other side.
What is the urgency?
The urgency is that petitioner's candidature in physically handicapped category has not been considered, and thereafter he has not been selected for the service. My lord, challenging the inaction matter, the petitioner has filed this writ petition, my lord. And he has not doing anything wrong.
Wait for some time. Wait for some time. Wait for monthly list. Only enlistment of the matter will not do. Court is to dispose of the matter. Wait for some time. In the month of August, you will come. Monthly list of August.
Mention for upgradation matters. Item number 44 and 171. First one is my lord,
What is the urgency?
that my lord, emotional benefit are not given as a result, my lord, service is not continuing. In the particular circumstance, my lord, coordinate several coordinate bench was pleased to pass on the direct action the conditional benefit. And they are getting, my lord, but the petition is not getting, my lord.
Monthly list of July. Monthly list 2 days. Monthly list will publish on Monday. Okay, let it appear in the monthly list. Let the court or you all consider what is the condition of the monthly list. Then you mention for upgradation. Monthly list of July.
My lord,
Both monthly list of.
may I be permitted?
Now I'm coming again from this side. Yes. First July. LIC matter. LIC matter direction, they have, yes. There are six petitioners, 8 petitioners, 6 petitioners have submitted their document, 2 petitioner has not yet, yes. Okay, they will, in that circumstances, they will within that period.
Any kind of made by the
Okay, there is a direction to comply with the within 12 weeks. Okay, 3 months will not, heaven will not fall. Okay, you will get some benefit LIC policy from there. It is not so urgent that
consider the prayer of the petition and the petition is happening.
on that date when the matter was taken up for hearing, the petitioner remained unrepresented. Petitioner remained unrepresented. This information, oh, the order has already been passed. So now you want modification that 12 weeks and let it be 8 weeks. No, 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 no. I am not so kind enough. Disciplinary proceedings. Okay, it is not ready for hearing. It is not ready for hearing. It is not ready for hearing. Okay, another direction will be given. They will come extension. You wait for some time. Wait for some time. No, 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 no. Don't act. Don't act. Yeah, yeah. You mentioned one matter. So why? No, no. Everyone has thousands, hundreds of matter. All will mention. Yes. Okay, let the monthly list come out, then we will mention. 2 days, within 2 days, nothing. I know, let on Monday, monthly list be published on Monday. I know, yeah, let the monthly list published on Monday, then you mention for updates. Oh, okay. You wait for some time. Let the monthly list published.
One motions matter of 2019.
Motion, you give the slip.
My lord, may I be permitted to mention 3 analogous matters? My lord, the petitioners are scientists who have been unlawfully terminated by IJRA and
Unlawfully?
terminated by IJRA, Indian Jute Industries Research Association. My lord, the last order that was passed in this case was on 22nd of August 2023 by my lord Justice Lopita Banerjee, who had directed the
Jute mill matter, jute mill.
Yes, my lord.
Jute mill.
Yes, my lord.
They are seeking benefit, subsidy or certain such.
No, my lord. They have been unlawfully terminated and they seek a reversal of the termination. My lord.
Employee.
Yes, my lord.
Employee of jute mill.
Yes, my lord.
They have been in a labor matter.
No, my lord. Jute Industries Research Association. So they were scientists. They are scientists. And the last order was passed.
Okay, monthly list of July.
My lord, while your lordship was pleased to take up this matter on 14th May 2025, my lord, this was directed, my lord, to appear after 2 weeks of the vacation. But till that, the matter has not appeared. Your lordship has heard the matter and directed the matter to be taken.
It will appear under the heading returnable matter. Under the heading returnable matter. When the matter is taken up, none appears. Returnable.
My lord, in presence of all other matters.
Okay. I am
taking up for you.
Okay, let the monthly list publish, then you mention for upgradation. You want recovery of that amount. Okay, wait for some time, yes. What is the urgency? Motion. Motion, give this. Huh?
The urgency is that we are getting regard to flying of a horse head.
Huh?
Flying of a horse head. Earlier there was a direction by
You take the mic, take the mic.
Earlier there was a direction by this honorable court where they directed the Kolkata Municipal Corporation to issue licenses to those who having the proper documents, my lord. License was were not granted since 2019, my lord. Since 2019, this petitioner is not having any earning, my lord, at all, and he is suffering a lot, my lord. If it
So what you are doing for last 6 years?
nothing, my lord, nothing at all.
No, what you have to do? What did you do?
Lord, I have
Why you
tried to
didn't do it?
mention many a times, my lord, these state authorities appear, they seek for
For the last 6 years,
yes, my
you
lord.
are mentioning.
My lord,
No court is
they-
accepting
they-
your mentioning.
They sought for time to file their affidavit in opposition. That has not been done since 2020.
So the matter is not ready for
My lord,
hearing.
it is ready for hearing, my lord. My lord, my lord, kindly,
Affidavit is not complete for
my lord,
ready for
let
hearing.
my lord, let it be upgraded in the monthly list of June, my lord. I have mentioned it before your lordship as well many a times, my lord. My lord has rejected.
Monthly list of August.
My lord, it is appearing in the monthly list.
Monthly list of August.
My lord, it is appearing in the monthly list, my lord.
Appearing.
Yes.
Okay, let the monthly list publish, then mention.
This is a hearing matter. I'm for the petitioner, and it's regarding the absorption of SSB Shashastra HON'BLE, and kindly consider the inclusion in monthly list.
Regularization. You wait for some time. Yes.
My lord, 2017 writ petition, illegal termination was challenged. My lord, final hearing stage, affidavits have been exchanged. This matter last came on before your lordship only. A supplementary affidavit was filed. I am praying for inclusion in the heading hearing in the monthly list of July. But my lord, kindly
Monthly list of
upgrades
July.
the matter in the monthly list of July, my lord.
This is regarding the professor and director in charge.
Grateful.
Regarding?
The professor and the director in charge of Indian Institute of Management, Calcutta, the Joka Management Institute, they have retired from their service.
It is public is or private?
This is public. This is public. Absolutely, it is governed by the Ministry of Human Resources and Development, Union of India. They have floated a scheme long back in 1987 regarding conversion from CPF to GPF, and the petitioner adopted that scheme. That scheme consists of pension. The petitioner can obtain that scheme, and this honorable court had passed in division bench. Justice Mantha has passed order that the other person has granted pension scheme. The Supreme Court in other matter also held that in similar situated institute like
A monthly list of July.
Inclusion. Inclusion. My lord has allowed the inclusion earlier. It directed my lord directed the matter.
The matter is already on list in the list.
No, it is not appearing. My lord directed the matter to appear in the monthly list of June. It did not appear.
Monthly list of June, it did. Okay, monthly list of July. Okay.
May I be permitted to mention some matter of group 2 hearing for inclusion, my lord?
What is the urgency?
My lord, all the matters have the urgency of transfer upon medical ground, my lord.
Transfer education matter.
My lord. Group 2 matter, my lord.
Hearing matter.
Yes.
Transfer hearing matter.
I'm mentioning
Monthly list of July. Yes.
আমি পিটিশনার মাই লর্ড আই এম দ্য পিটিশনার মাই লর্ড আমি ব্যাংকে সার্ভিস করতাম আমার ক্রিমিনাল কেস হয়েছিল
You take the mic.
আমার কাছে ক্রিমিনাল কেস হয়েছিল আমি অ্যাকুইটাল পেয়েছি এখনো ব্যাংক আমাকে কোনো কিছু দেয়নি এই জন্য আমি পিটিশন করেছি
তা আপনি ক্রিমিনাল কেসে যে অ্যাকুইটাল হলো সেইটা আপনি অ্যানেক্স করে অ্যাপ্লিকেশন করেছিলেন?
না তখন স্যার আমার লয়ারটা যেমন বলেছিলেন
আপনি রিটায়ার ক্রিমিনাল কেস চলাকালীন আপনি রিটায়ার করে গেছেন?
না তার আগে আমাকে ডিসমিস করে দিয়েছে।
ডিসমিস করে দিয়েছে? ওরা প্রসিডিংসও করেছিল ডিসিপ্লিনারি প্রসিডিং।
আরেকটা অন্য অ্যালিগেশন এনে অন্যভাবে প্রসিড করে ওটা ডিসমিস করেছে আমাকে।
তাহলে ক্রিমিনাল কেসটা আলাদা অ্যালিগেশনে আর প্রসিডিংসটা আলাদা অ্যালিগেশন।
সেম অ্যালিগেশন।
আচ্ছা,
মানে ডিফল্টেশন অফ মানি।
ইয়েস।
একটা টাইমে সেটাতে আমার এগেইনস্টে ক্রিমিনাল কেস হলো, পরের বারে ডাইরেক্ট চার্জ হলো, সেটাকে ক্রিমিনালে গেল না, ডিপার্টমেন্টাল করা হয়, ডিসমিস করা হচ্ছে,
হ্যাঁ ডিসমিস করে দিয়েছে।
কিন্তু কোনো বেনিফিট আমাকে দেয়নি।
এই যে মান্থলি লিস্ট অফ জুলাই দিন, এটা মান্থলি লিস্ট অফ জুলাই, মান্থলি লিস্ট বেরুক, তারপর আপনি মেনশন করবেন। ওকে, আপনি স্লিপ দিন। এগুলো কি দিচ্ছেন? এগুলো তো মামলার সময় দেবেন। আপনি শুধু নাম্বারটা টুকে নিন, নাম্বারটা টুকে নিন। এবার আপনি জানেন আপনার আদার সাইড কে?
ইউনাইটেড ব্যাংক অফ ইন্ডিয়া, এখন পিএনবি।
এখানে কোন অ্যাডভোকেট আপনার
না, আমি
দাঁড়াচ্ছে?
এর আগের দিন ক্যাপিয়ার সুরেন্দ্রবাবুর ওখানে ছিল, উনি আগে করে বেরিয়ে গেছেন, আমি বলতে পারবো না কোন লয়ার ছিলেন।
ও, তাহলে আপনি একটা ব্যাংকে গিয়ে চিঠি দিন। আপনি ব্যাংকে চিঠি দেবেন যে আজকে আপনি এই ম্যাটারটা মেনশন করেছেন, এই ম্যাটারটা মান্থলি লিস্টে উঠবে, ঠিক আছে, এবং যে কোনো দিন এটা নেওয়া হতে পারে, ঠিক আছে?
ব্যাংকে কপি দেবো আমি।
হ্যাঁ,
ব্যাংকে একটা কপি দেবো।
কোর্টের বিজনেস যেমন পারমিট করবে, যে কোনো দিন নেওয়া হতে পারে। ওকে, হ্যাঁ। Honorable Justice?
দেবব্রত মন্ডল।
Oh, you take instruction, then come. You are not fully aware of the information with the information of the carriage of proceeding. Okay, you take information, come on Monday. Come on Monday. Yes, yes. Call the list. Call the list. Yes.
Item number 1, I'm for the petitioner, Your Honor. On the earlier occasion, my learned senior friend has submitted one order along with a list of lordship pending cases which has been, as per their claim, has been disposed of. Lordship kindly takes up, that was submitted before Lordship, Your Lordship. Kindly takes up the Lordship list of
what is your there are some more appeals are pending before them.
Your Lordship, I can show your Lordship. Kindly takes up their list, Your Lordship. There I can show your Lordship that there are still certain second appeal which is pending. Lordship, kindly see lastly the June 22.
All the 8 second appeals and complaints submitted by such and such for disposal are closed without any further action.
Lordship, I'm talking about this particular list, Your Lordship. Lordship, kindly see the
whether this list was brought on record.
That was
On the
submitted
last
properly.
occasion, I had handed over to your lordships.
Handed over this thing.
Well, I can also again, my lord. And this is the list we took up the matters conjointly hearing as per his own, my lord, request, my lord. And the order is passed. My lord, kindly see his prayers first, my lord. His prayers to, my lord, dispose it of his, my lord, the second appeal. Conjointly. And that is several next time, my lord, he made a representation. All my second appeals be heard together and pass an order. My lord, we have passed an order.
Lordship, kindly
Now
see
this
prayer
order is a fresh cause of action, lordship.
Lordship, kindly see prayer number 8, Your Lordship. Lordship, kindly see read in the nature of mandamus commanding the responsible authority, their main agent, finance and/or executive office to hear out the appeal dated June 20, 2019, being Annexure 19 and October 17, 2019 and October 12, 2020. Now, Your Lordship, the second two.
No. My lord, he is, my lord.
You even did not mention the name of the appeals or number of the appeals also.
Lordship, that was not given to me. Lordship, kindly.
No, my lord. What he is saying, my lord, the first one is the second appeal, my lord. Next two are the reminders of the same second appeal, my lord.
It is an order of the Honorable Justice Devanshu Bosak. Your Lordship, kindly comes to your Lordship, page 85, Your Lordship.
But kindly see all the three annexures, my lord, your lordships will
Lordship, this
understand.
order was passed, Your Lordship, and I have mentioned, Your Lordship, in paragraph number 22 onward, Your Lordship, why I had to prefer October 17, 2019 appeal, Your Lordship. Kindly appreciate. Lordship, kindly.
What order?
Paragraph 85, Your Lordship, 85. Order, page number 85 of the.
So,
Lordship, this order says I have.
Order has stated that all are first appeal stage. If the petitioner is aggrieved with the order passed at the first appeal stage, petitioner has liberty to file second appeal.
Lordship, kindly comes to Your Lordship, paragraph number 24. Lordship, kindly, for once, Your Lordship, kindly. Paragraph number 24, Your Lordship.
Page
You are Mr. Saha. Saha.
I am.
You are Mr. Saha. Your name, good name. Petitioner name Wajid Ali Sardar.
But I am
Huh?
but myself, Mr. Shah.
Oh. Oh,
Page
Sardar.
85 is a reminder of page 82, Lordship.
Lordship, page number 12.
The appellate second appellate authority by giving a written instruction and written statement before a court of law has stated all your pending appeal have been disposed of.
But your Lordship,
Now, if you want to contradict this statement, then you have to come with no statement, no oral statement. You have to come with specific information that no, this statement is not true.
Lordship,
Then court will take action.
Lordship, my humble submission is there are still what I prayed for disposal of the second appeal. There are still one second appeal which is pending and which is not included in the list, your Lordship. Lordship, kindly comes to.
So your submission come to be specific. Your submission is that one appeal is still pending.
Your Lordship.
What is the number of that appeal?
Number has not been given, your Lordship.
So how can you understand from the numbers that these are the appeals where his
The
appeal
date,
is not
your
there?
Lordship, the complaint date.
It's a vague application.
Lordship, the
It is a vague statement that I prefer the appeal number has not been given. Then, don't argue. Change the habit of giving reply to every word. That is bad. So if before any appellate authority in our country, you prefer an appeal, present the memo of appeal, but you are not provided or supplied any number, then you must write. You let me know what is the number, whether my appeal has been registered or not, and if registered, what is the registration number?
On their part, your Lordship, they did not provide. They have only received my appeal. Lordship, for once, your Lordship, kindly comes to your Lordship, page number 14, paragraph 22 onwards, your Lordship. This will your.
So I am disposing of the eighth petition based on your information that all the pending appeal preferred by the gentleman, namely Wajid Ali Sardar, have been disposed of.
Lordship. But this is an order of commission, below. This
Ajay.
is not information.
Yet you will again examine the record. If any appeal remains pending,
That will be
it will make a sincere report to dispose of the same.
Absolutely, Lordship.
Lordship,
Absolutely. I agree with
Lordship, kindly, Lordship.
I'm accepting your
Okay,
Lordship.
Lordship, October 17th.
the present, okay. I think after this order or statement coming from the Item number 2, restoration application. Restoration application আছে রেস্টোরেশন অ্যাপ্লিকেশনও আছে তাহলে কি করবে নট টু করে দিন আর কি পাঠার ম্যাটার
Item number 3, my lord, I am for the petition. But this matter has already been heard by your lordship. It is related with an order of the district magistrate. 24 South Path in connection with the Sarai Act. And the
Sarai license.
And the
Yes.
building is under the lock and key. My sole prayer is that whether I don't want to continue any business as because there is no license at present. But the last 9 years, the building is under the lock and key. Presently, building necessitates some paints, repairing, etc. So that building may be even I will stay there. I will not continue any business. And I have already.
It has been seized in connection with a criminal case.
Criminal, but no, that I have already earlier occasion.
Mr. Chakraborty, it has been seized in connection with a criminal case.
District Magistrate, there were allegations, my lord. There was initially, my lord,
Allegation that he was using the.
I don't want to go into those issues.
Yes.
My lord, those issues has already been addressed, my lord. There was a direction from the court to revisit the issue. It was done by the district magistrate. And it was found that they have been illegally using it. Now the only contention that what he is saying that he wants to go back to his own house, not to do any business. Only difficulty is, my lord, would kindly come to my opposition at page 18. Page 18, paragraph 18. There is already a case that this is a unauthorized occupant. He has been declared by West Bengal subdivisional magistrate. Paragraph 18.
So proceedings under West Bengal public land.
Yes,
Eviction of unauthorized occupant act.
Where he has been declared as an unauthorized occupant. He says he has challenged the same.
Only one thing I say, my lord, that I have already mentioned in the reply that the land pertaining to 2.5 decimal is kept aside. And this building is over the land which I own and my mother owned. I have annexed that document. And pertaining to that dispute, there is an appeal. And in connection with the appeal, a writ petition is also pending before this honorable. So that is a separate issue. And we are
And
not.
let him make that prayer before that court. Because if he has
No, no,
already
yes.
been declared as an unauthorized occupant
It is-
of that premise,
It is
but
not in connection with that. My lord, what we need that the building is over the land. Kindly come the reply.
No, whether why writ court will enter into that dispute.
No, I have kindly see that I have specifically mentioned in the reply. In the reply, I have said how the land is and where the building is over the land. Kindly come. I have taken care of that situation. But this land is given. Your lordship, kindly come page 5, paragraph 9 of the affidavit in reply. There I have annexed the sale deed.
So you have made some certain amendments.
No, along with that document.
And contradicted,
No, your lordship,
controverted that amendment that it is.
even in the opposition, they have relied upon the records of right. In the records of right, it is reflecting that the part of the land, 2.5 decimal is of the vested land, and other 8.5 decimals is owned by myself and my mother. And the building is over that land. And 2.5 decimal land is still kept in apart. As because it is a land vested, we understand that land is in the dispute in connection with the unauthorized, etc. occupant, but that matter is pending before this court also. So where the building is situated, it is also admitted position in the record of rights when the state has also given. It is annexed here. And in the record of rights, it is depicted that the land is owned by myself and my mother, and it is given by a deed of gift, certain part, and certain part is owned by mother. This is the position, and the building is over there.
Maybe.
May I
So whether any demarcation was made? Any demarcation?
No.
Huh?
No.
So
Demarcation is not, but kindly come paragraph.
the authority from land department will go, the land will be demarcated.
But
That this land is a vested land and this land is a.
As because your lordship kindly come, as because it is the land measuring about 11 point something decimal. 2.5 is vested. When the rest 8.5 decimals is with me. And the building is there.
There is a disputed question of fact.
That is, my lord, I have taken
A
care of
rich court cannot be invited to enter into such dispute.
No, unless the building, so that.
And that apart, you are asking the court to based on your oral assurance.
No.
Oral assurance.
Well, that I may.
Admittedly, you caught what I say.
I have not been caught.
For using your building, maybe it is even your building for immoral purpose.
But may I say something?
You are using the building for immoral purpose.
May
Okay, state has settled the land in favor of every citizen for a particular purpose. And the house you are belonging, the state has settled the land for residential purpose.
No,
the agricultural land to for agricultural purpose. One pond for pisciculture purpose. But if you change of user, then land may be taken back by the state.
May I just submit? There is a license. The Sarai license was granted by DM. But thereafter,
license to run a bar.
No, not bar. It was not a bar, even bar. It was
also op shop.
It was not foreign liquor op shop. This building, there were some persons who were staying with their girlfriend, and then they are. And that's why. Then a proceeding, one thing.
So you allow the some person to stay in your house with some girl.
My learned senior friend has personal
Your
knowledge.
Lordship can see that I have already handed over a judgment. Similar situation has dealt by.
Actually, Mr. Your conduct does not inspire confidence in the mind of the court that no similar offense will be committed if the house is given in your possession again.
May I just to that
Okay. Your conduct is not sufficient to inspire such confidence in the mind of the court.
I may reply, to that extent. But your Lordship's kindly says continuation of that was when I was with the license of Sarai Act. But at present it is revoked, and revoked last 9 years. The building is under the lock and key. So I do not have any opportunity to continue any business unless I do not have the license. As because license is revoked.
Oh, so one Sarai license is required as a passport.
No.
As a license.
It is not that passport, but I just want to stay. If your Lordship's kindly pleasure, your Lordship's kindly direct me as to some so that I may undertake to the authority concerned that this building will not to be used in any other purpose. But whatever, I just draw your Lordship's attention. This situation was dealt by the High Court at Chennai. But I have already handed over the judgment. Their similar situation was there. The building is unlocked by the order of this court. Even here, this court also, Justice Bhattacharjee, also dealt similar situation in another matter.
So that judgment.
The judgment of Chennai High Court I have already handed over. This is
This court, first this court, then Chennai High Court. Okay, give a copy to your learned friend also.
I will.
Huh?
I will.
Yes. He will point out
The wrong
what is the distinguishable factor. Oh, yes. Paragraph.
But paragraph, then I am to read certain paragraphs. Otherwise, it is my.
Certain paragraph, no.
Because there are certain, the entire.
Come on, pattern point. Yes. Paragraph.
চেন্নাইটা নয়
চেন্নাইটা হেল্পফুল আমাদের এখানকার সুপ্রজাতি ভার্সন মানে লর্ডস উইল ফাইন্ড ফ্রম প্যারাগ্রাফ 17 onwards. The judgment of the Chennai High Court quite helps me.
Yes, Mr. Chakraborty, what is your instruction?
My lord, there is an issue of, my lord, he cannot be allowed to run the hotel any further. Man, that is now, my lord, what I find from the record, my lord, that there is, my lord, would kindly come to page 69. Just
69
of my opposition. What?
Yes.
Whereas it appears, the proceedings I had said,
Yes,
it
yes.
appears from the report of the BLR of Falta, memo number dated that an unauthorized encroachment had been made in plot number 844 and 845 in Moja, so and so. By one Shukhendunath Bhattacharya, who is the petitioner before my lord, who is the recorded riot of portion of plot number 844 and 845, but not the owner of the entire area of the plots. Sri Bhattacharya unauthorizedly occupied 2.5 decimal plot of plot number 844 and 2 decimal plot on plot number 845, vested to the state by constructing hotel lodge under the name and style of Hotel Riverview Falta. BLR of Falta also requested to make the government vested land encroachment free as per the provisions of law, so that the government vested land can be utilized for various development projects for the greater interest of the public. DA of the entered the case, relevant requisition, and so and so. The final order, my lord would find, starts from page 75.
Yes.
My lord would find first, second, third, fourth paragraph. On the basis of the report, Sri Bhattacharya was asked to show cause on 28 July as to why an order under subsection 1 of section 4 of the said act shall not be made against you for unauthorized occupation of government land on the first date of hearing, that is on 28 July 2015, appeared and intimated the undersigned that he prayed for a long-term lease for the case land his prayer is not disposed of by so and so. With this statement, Mr. Bhattacharya admitted undoubtedly that he is occupying the vested land. Ultimately, my lord, the last paragraph, starting penultimate paragraph, now therefore, in exercise of powers by section or so and so, I do hereby order to vacate and remove the unauthorized occupant, Sri Shukhendunath Bhattacharya. And my learned senior friend says this is subject matter of challenge in a particular writ petition.
Before that, your lordship kindly come also the page 76. There is something to say. Well, may I read that part? At page.
Collector has already passed an order directing to demolish the structure.
Thereafter, then
Structure that will be a building.
No.
So how in this writ petition I can
that is what
I can direct the
writ petition.
I can direct the collector that you allow him to use.
No, it is not that. Your lordship kindly come entire order. Then kindly come page 76 as referred by learned.
76, yes. Demolish the structure and other property lying over the case plot number ato with area of ato, out of ato, and plot number ato with area.
Before that, kindly come.
So
I am reading the middle part. Your lordships kindly come.
Yes.
The case land being plot number 844 with area 2.5 decimal. Out of total area 0.5 decimal. And plot number 845 with area 202 decimal out of 8 decimal of Mauja Basular, these are vested to the state. That I am saying the entire plot of 2.5 decimal is vested to the government. But other remains with me. And it is also in the record of rights state of West Bengal relied here in the opposition. Kindly come page 27, 26. My name is appearing and mother's name also appearing in respect of the other land. The building is there and 2.5 decimal land is there keeping apart. Your lordships kindly direct that me that 2.5 decimal land as
No, why?
then your lordships kindly to that.
That would be tantamount to giving a declaration that you are owner of that part. You are not owner of that.
No, I don't want that. But it is reflecting itself from the order itself reflecting that I am owner in respect of the 8.5 decimal. And 2.5 decimal is mallet with the vested land. But the building is over there.
Mr. Acharya, first court asks you question whether there was a demarcation. Answer came
no.
from you, no.
No.
So when there is no demarcation, it has not yet been decided which portion of that plot of land belong to you and which portion plot of land belong to the government.
That
is a joint property conception.
That's right.
Come. Every sand, piece of sand is joint.
It is reflecting from.
So let the officer come. Let the officer demarcate the property. Then you can claim that this building is mine.
Then officer is from.
When the officer can tomorrow state can claim the building is the belong to the government. That portion is the vested.
That should be before that writ petition. Why is challenged?
No. Kindly come. Kindly come. Your lordship, before that, kindly come page 26. It is there. Which one is under the vested? Mother, kindly sees page 26.
Okay, that memo 16 memo. Where is 16 memo?
Kindly come page 26 of the opposition. May I draw your lordship's attention? Page 26 of the opposition. Kindly sees that there is Dokanghar 0.5 decimal. That is my lord collector's land. Page 26, kindly come. Page 26.
Court will not enter into that.
Don't want to that extent. What my part is that
evidence is required to be.
These are
Where is that memo? You just show that memo. You have challenged in this petition.
That is my lord.
Page number. In the petition, you have challenged one order dated 27th July 2016. 27th July 2016. Where is that?
No, order challenge, my lord.
54, my lord. Writ petition 54, 21st July.
Page 54. Hmm.
My lord,
Actually, you have challenged an order by which the district magistrate refused to revoke the and or withdraw the order dated 23rd June 2015, by which your license, Sorai license was cancelled. This is the subject matter of the writ petition. Okay, now you say what wrong the district magistrate has committed.
Initially, well, there was an order. That order was challenged before this honorable court, as because the order passed by the ADM. ADM doesn't have any authority in terms of the Sarai.
Now district magistrate has passed the order.
Yes, but what is district magistrate is done, basically the order as passed by the ADM, that is reflected. There is nothing new. First, the second thing is that it is the important question that while you are exercising section 16 perhaps in the Sarai Act to revoke my license, then the authority in terms of the Sarai Act you are seized. You cannot thereafter say the building is to be locked and key. As because I am suffering, as because
their action to keep the building under lock and key is not under challenge in this writ petition.
No, yes, as because this is exceeding jurisdiction.
This writ petition come to the pair portion. What you have challenged? Pair B, you have said open the padlock and key. Okay, sorry, Mr.
The one thing your lordship kindly sees that if the building remains, it is over the land as because
they have directed you to remove the structure from the property.
Then the building is of the land is to be damaged and destroyed. Then I will suffer much as because
it has not been decided which portion of the land belong to the government and which portion of the land belong to you.
May I pray one thing? My lord, this is to be done by the revenue inspector. Revenue inspector of the block is
you submit application. They let the demarcation be taken place.
Your lordship kindly direct that authority so that removal, so that the demarcation is to be done. Then I will come back with this writ petition. Kindly pass the order. That will do, my lord. Otherwise, the entire building, two-storied building, is to be damaged. So if there is even there was an application from me as to get the lease in respect of 2.5 decimal, they have not done. It is kept pending. So it is the land over with which I own. I have annexed here that document of sale deed and also the gift deed as given by my mother. The entire I have here.
Your pair can be entertained in another pending petition where you have challenged the order passed by the collector under West Bengal public land eviction of unauthorized.
Yes, but that is in
okay. Let the determine here. Total the issue is different.
May I just
in this petition, it would not be proper to entertain such pair. Otherwise, that petition will be.
Yes, may I just draw your lordship kindly see that dispute pertaining to 2.5 decimal. Even if they in other court, it also in respect of the land, that is in respect of 2.5 decimal.
I am to repeat again. Since you are repeating, I am to repeat.
So that is your lordship.
The demarcation has not yet been made.
So unless
in respect of a joint property, can any co-owner claim that this particular person belong to me?
Here is quite.
Here also, unless there is a demarcation, if any portion of the land is vested to the state and other portion remained with the owner thereof, then there must be a demarcation. Revenue officer come, there must be demarcated, and even barter plot would be made.
But here it is quite different from others, as because the record of rights says that the 2.5 land is a shop room. It is specified here.
So the what has been recorded, that is.
This is also part of the evidence, as because it is done by the authority. kindly come in the page 26 and 27 in the opposition.
You agitate this point in another writ
No,
petition.
no, another
Okay.
writ petition. And
Unless there is a demarcation, Mr. Ashaji, kindly consider, unless there is a demarcation, today you cannot claim that this building belongs to me.
my lord, your lordship kindly see
Okay, the government can claim this building belongs to me.
this issue could
Unless there is a demarcation. So which part of that 5 decimals have been vested, has been vested, that is yet to be decided.
may I just give a reply?
Yes.
My lordship kindly sees that so far the demarcation of the land and possession of the land, yes, it is not here in the issue. It is here in the issue whether the order passed by the DM is absolutely tenable in
Cancellation of refusal to withdraw the cancellation of your Sorai license.
That's right.
That
So,
is the issue.
first part. A second part is while the power of DM is completely exercised and says that yes, your license is revoked. Can DM can DM pass any further order going beyond the Sarai Act to lock and key?
Okay, okay, you hear
That-
you listen to the order, you listen to the order. Ask him. The present petition challenge the legality and propriety of Next,
Number 4.
4.
I have to get Malat. This is short matter, although Malat, ABTV has been already exchanged Malat. This is a matter regarding Malat decision by the Malat respondent Malat with ex parte order. Iloshi kindly come to Malat page 90.
Okay, I'm coming.
Fact of the case.
You want setting aside the ex parte order dated 21st January 2022. Yes.
The huge demand Malat, that is 26 lakh 55,456. I am a cable agent Malat with Malat small business Malat.
GST or income tax? GST.
Service
Yes.
tax.
Oh,
Service tax.
Service.
It is now merged with GST.
Huh?
Sir, Your Lordship, previously there was two other statute that is central.
Now all merged with GST.
Both have merged with GST, goods and services tax.
So they have imposed a penalty of rupees 3,85,000 such and such. This order most probably appealable order.
So Malat, that has.
Have you preferred appeal?
Yes, Malat. I made appeal application Malat.
Where is that?
Appeal because Malat, because of ex parte order Malat. I cannot Malat made appeal Malat.
Preferred appeal? Preferred appeal?
Because she kindly come to Malat.
Preferred appeal, the pendency of the.
Kindly see that order Malat only similar facts Malat, division bench Malat. And subsequently Malat, Supreme Court Malat. Similar facts Malat. Regarding agent and other things Malat, you will see kindly come to that order Malat, that portion Malat. That is para 6 Malat, page 2. Under normal circumstances, the court would not enter the plea raised by the appellants since the appellants were not diligent in prosecuting the matter, and despite notice they have not responded to the authority and put forth their case. However, two facts which have been weighted in our mind to grant relief the appellants are firstly the basis for issuing the show cause cum demand notice dated 28 December 2020 in our account of the fact that the adjudicating authority accumulated the ST3 return, that is similar as of the appellants, and income tax return and found mismatch, and consequently proceeded to issue show cause notice proposing the asset, the service tax on the entire amount. The assessee case is that there are two components to be among.
Distinguishable on fact. It is not.
Similar question, Mala.
No, it is not.
Similar question.
You preferred appeal. You preferred appeal. I am trying to give you some relief together. You entertain the appeal without raising the, or you will be at liberty to raise the issue of pendency of this petition to justify your delay in preparing the appeal.
Yes,
Huh?
Yes, submit my.
If
Lordship, kindly see the order date, my lord. 21st January 2020.
When you filed this petition.
Yes, this is the whole thing.
Because of COVID period, Mala.
COVID.
So I cannot condone the delay before presentation of the petition.
The read court can, Mala. Because of Mala, because subsequent fact, Mala, you will see kindly come to Mala page.
Cause of action cannot come.
Because Mala, because
and that apart,
COVID situation, Mala, circular is.
You read this point.
My lord, Supreme Court order is there after if the petitioner
no,
is so aggrieved
no.
against the adjudication order, he has to approach this honorable court within the statutory period of time. Now
That is another thing, my lord.
No,
But
let
COVID
me
situation,
submit.
my
Now
lord,
here my lord statutory period is 60 days, which is condemnable further 30 days, 90 days, my
that
lord.
I know. That
As
I
per
know.
section
Your
35.
lordship
Now
knows better
when
than
he has
me.
approached,
Better
when we have issued, even in the year of 2022, we have issued him the letter, kindly intimate us whether you have preferred any appeal or not.
situation, my lord.
Well, 22 July
Yes,
2022.
my lord. Then
How
the
the COVID
subsequent, my
situation
lord,
will come?
I filed my
Again, my lord,
lawsuit.
in the year of 2023, we have issued a demand recovery notice. Even he has not turned up in the year of 2024, January 2024, he has filed this writ petition. There is absolutely delay, laches, negligence on the part of the petitioner to approach this honorable court, my lord.
Not true, my lord.
And if your lordship kindly see the order of the honorable Supreme
During
Court,
my lord,
Supreme Court has categorically held.
my lord,
even-
they are not.
If two persons started shouting at the same time, whether it would be
I would say, my
possible to hear or understand, I don't know. I have no super brain.
No, my lord. That is my application. I can say, my lord, much better. My lord, what, my lord, regarding my lord, admission time, my lord, they have no objection, my lord. You see, last order, my lord, passed by my lord, Rashid Nizamuddin, my lord, no objection, my lord. Nothing has been done, my lord. Only that before disposing the application, they are made, my lord, that type of, my lord, objection. You see, kindly come to my medical report, my lord, page 23, my lord.
Court is for those litigants who are vigilant.
You see, kindly come
I can say, if you allow me, I can open my laptop. I can say the maxim also. Court is for those litigants who are vigilant. The order was passed in the January 2022.
Yes,
You very much aware. Ignorance of law is not
situation.
Ignorance of law is not excused. It cannot be excused. That it is an appealable order and the 60 days, and it can be extended up to 90 days.
That has
30 days
passed over.
more. So 90 days April. Okay. And the COVID period, the limitation was excluded up to 28 February 2022.
Yes, my lord. That is my lord.
There is a judgment that thereafter
then
none can take.
Yes, my lord. And that's
it cannot be staged so elastic. It can be go on.
No, that is not, my lord. But after some time, my lord, you have to kindly come to my lord, page 23, my lord, my medical report, my lord. I is my lord admitted at Bangalore hospital, my lord. That is a problem, my lord.
You filed an application for condonation.
Yes,
they will consider.
Yes,
they will consider.
Yes, you have to
And
kindly give
I
the-
can also give the relief or setting that you will be able to raise the issue of pendency of this writ petition to justify the delay. Why I am giving section 14 of the Limitation Act.
Yes, sir. Kindly.
And but I am not giving any.
the judgment, my lord.
I am not giving anything new.
Yes, my lord. Division
Which
bench
is
judge.
given section 14 of the Limitation Act.
And
If
also,
it
my
is
lord-
filed in the wrong forum, then that period would be excluded. I am borrowing that principle and applying here.
Yes.
That you will be able to raise the issue of pendency of this writ petition to justify the delay in preferring the appeal. Only that much I can
Also, my
give
lord,
you.
you have to rely, my lord, division bench order.
Huh?
Passed by Chief Justice, my lord. Similar confession.
With due respect, my lord, over here, it is a hearing upon affidavits. My lord, your lordship has to either allow the writ petition or dismiss the writ petition. My lord, in my respectful submission, we have raised the preliminary point of with regard to alternative remedy, then the question of delay and latches on the part of the petitioner, and moreover, in the pleadings, there is no justifiable reasons which have been assigned in the pleadings to justify that on this ground, the court should exercise some discretion in favor of the petitioner.
Can say,
My lord, without any pleadings on the air and with the oral submission of my learned friend, the court cannot extend or exercise some discretion in favor of the petitioner. Kindly see the pleadings of in the petition, just 4 or 5 pages, paragraphs. Kindly see the pleadings and satisfy.
Mr. Chakraborty, you know very well better than me that it is a judicial review. scope is very limited. You know, again, it would be
But court
repetition,
can say, my lord, Supreme Court has said,
illegality,
my lord,
irrationality, impropriety, doctrine of proportionality, such and such. No such thing has been
Supreme Court, but
agitated.
Section 5 application was always admitted. 7 years.
Section 5, I am not dealing with Section 5.
That is also my
No,
limitation. That is also limitation part, my lord. Nowadays, my lord, they are coming to merit, my lord.
Even government is put to task.
I mean, the petitioner has challenged Writ petition challenge. Writ petition challenge. It's challenge the legality and propriety of the such and such. Yes, yes. Next.
May it please your lordship, my lord, I appear for the petitioner. Lord, I am filing an exception. Lord, the respondent number 4 and 5 filed a report. Lord, I am filing the exception. I think the state, I have served upon them. Lord, I have received a report from the state authorities. This is the report, Lord, not in the form of an affidavit, but I have taken exception as per lordship's order. That was exception completely. Matter relates to acquisition of land by under the Railway Act, Miller. I'll be very precise.
Yes.
I'll take one note of it.
You want quashing of the order?
Not that. Lord, my submission before your lordship is that the railway, the 2013 Act says that the acquisition, the benefits of first, second, and third schedule would be applicable to the acts coming under the fourth schedule. Railways Act is an act which comes under fourth schedule. This acquisition is made under the Railways Act. So the market value is to be calculated in terms of section 26 to 30 of the 2013 Act. Lord, second schedule, the benefit I should get. Third schedule, the benefit I should get. Lord, as per the Railways Act, section 20, my lord has been through, my lord, the Highways Act, 3G, section 3. Lord, the jurisdiction of the arbitrator is only restricted to enhancement or decrease the amount, not to grant any other benefit. That I'll try to demonstrate, that he can only see whether it is enhanced or decreased. Suppose X amount is given by Kala, say 1 lakh, hypothetical amount. I am not happy with that. I go to arbitration, he can increase it. The authorities goes to arbitration, they can decrease it. But the other benefits which I am entitled to under the 2013 Act, the arbitrator is not entitled to give that in terms of the law. That's my preliminary submission. Not I have filed an arbitration. An arbitration has been taken out. Now, my lord, the divisional commissioner is the arbitrator. Primarily, I am seeking for two reliefs. One, my primary challenge that under the Act, he cannot give me those benefits. Writ court should give me their benefit. My lord, if my lord is of the view that second schedule and third schedule benefits the arbitrator can give me, if my lord provides that, then I'll go back to the arbitrator. Second, what I am seeking, রেলওয়ে একটা বই দাও, বলি তাহলে বই দাও। হ্যাঁ, হ্যাঁ না বই।
Yes.
Not kindly have a look at the Railways Act, the 2013 Act though. Not kindly first take 2013 Act.
Yes.
Not kindly come to section 105. Now, let me first satisfy your lordship on the legal issues. Facts are almost admitted. Kindly look at the law. Take section 105.
Yes.
No, kindly read 1053 with me. 105 subsection 3 with me.
Yes.
The central government shall by notification within 1 year from the date of commencement of this act direct that any of the provisions of this act relating to the determination of compensation in accordance with the first schedule and rehabilitation and resettlement specified in the second and third schedule. Now, rehabilitation and resettlement specified in the second and third schedule being beneficial to the affected families shall apply to the cases of land acquisition under the enactment specified in the fourth schedule, or shall apply with such exceptions or modifications that do not reduce the compensation or dilute the provisions of this act relating to compensation or rehabilitation and resettlement as may be specified in the notification. So the central government by notification, publishing notification, this is not the source of power, that by notification they can apply first and third schedule to the act specified in fourth schedule. I'm not kindly come to fourth schedule of that act.
Fourth schedule, page. Yes, fourth schedule.
Not kindly sees in the fourth schedule. Kindly
Fourth schedule, Railway Act. You will show Railway Act.
Yes. So, first
Railway Act, where is the Metro Railway?
But we are concerned about entry number 13.
13.
Ah.
Yes,
Railway
Railway Act.
So, as if
It
there
is
is a
scheduled act.
if there is a notification, 1, 2, 3, I'll get the benefit. But there is a notification, admittedly, I have annexed that, I'll show. Now,
Now
kindly,
you want benefit
kindly
regarding
take
the
first
schedule
schedule
2 and schedule 3.
kindly take first schedule.
Rehabilitation and resettlement.
But kindly just see first schedule first. The first schedule,
First schedule,
they admitted, they are giving me the benefit.
market value such
First
and such.
schedule, market value,
They have given benefit.
market value multiplied by the factors, then solatium, everything. Take the second schedule. What I am entitled to get, second schedule comes under section 31, 38 and 1053. Then 1, provisions of housing unit in case of displacement. So in case of lost in the rural areas, a constructed house shall be provided as per the Indian Awas Yojana so. If a house is lost urban area, a constructed house shall be provided, which will be not less than 50 square meter in plinth area. This is 1. Then 2, benefit listed above shall also be extended to any affected family which is without homestead and so. Then kindly come to 3, land for land. 2, land for land in case of irrigation project as far as possible and lieu of compensation to be paid for land acquired each affected family owning to agricultural land affected area. Then offer for development of land. Then choice of annuity 4. Then 5, subsistence grant grant for displaced. Then 6, transportation cost for displaced families. Then 7, cattle settle price. Then 8, one-time grant. Then 9, fishing rights. Then 10, one-time resettlement allowance. Then 11, stamp duty. So all these under the second schedule I am entitled if the acquisition is under Railway Act. Then look at third schedule.
Yes.
Component of infrastructure amenities proposed to be provided by the acquirer of land. Roads with the resettled villages as an all-weather land, so and so. I'm just no. So
and certain essential amenities.
All other amenities I am entitled.
Yes.
Now kindly now take the Railways Act.
Yes.
Why I say that the arbitrator cannot give me 2 and 3.
Matter, my lord, the land has been acquired by for the freight corridor. Well, the freight corridor is the necessary party, my lord.
They have filed the report.
না কেউ নেই ফ্রেড করিডোর নেই না উনি রেলে উনি ইউনিয়ন অফ ইন্ডিয়া ফ্রেড করিডোর মানে ডেডিকেটেড ফ্রেড করিডোর my lord. Respondent number 2 and 3.
Difficulty is the litigant is coming every day from Bardhaman. I am under lot of embarrassment. Now today they are not here.
Let them appear.
ওরা এক্সেপশন দিয়েছে, ওরা জানে তো, আমি কি বলবো বলো তো।
মিস্টার আগরওয়াল, সত্যেন্দ্র আগরওয়াল।
এই দেখো দিয়েছে, দেখো কাল থেকে রান করছে। হ্যাঁ বুঝতে, হ্যাঁ তাহলে এখন তাহলে একটা নোটিশ, should I give them a notice and come back then? Because I want to finish it. I have a good legal stand. Not should I show that section 20 or not? I should start on the next day. Because this way it cannot be completed. Now every time.
Next week নোটিশ দাও।
ঠিক আছে বলো তো। হ্যাঁ বুঝতে পেরেছি। রোজ এসে বসে আছে। হ্যাঁ বুঝতে পেরেছি। না ঠিক আছে। কি করি?
It's a matter of 2024. So,
Can be decided, my lord. They approach before the arbitrator. Matter is pending before the arbitrator since long 2023. Let it be completed by the
So
arbitrator.
I can do that. That's my second limb of submission.
So he is saying that the benefits under schedule 2 and 3
Let it be
cannot be given
that will be decided by the arbitrator.
arbitrator, yes. Whether
if my
arbitrator
lord-
is
if my lord-
empowered to give that benefit or
But
not.
if my lord, after hearing me, is of the view that your lordship will empower the arbitrator, because Justice Aniruddha Roy was of the belief that his lordship will write that the arbitrator can give me that benefit. If that comes in the order, I'm saved. Because otherwise, he cannot give me as per my understanding of law. But
No, in your statement of claim, which you have presented before the arbitrator,
I have claimed.
you have claimed that benefit.
Yes.
But
so it is under consideration of the arbitrator
but
concern.
under the law, Lord, I tell you, lordship, Lord,
Again, you are opening another forum.
Lord, what should I do when I'm coming to a court if I'm not convinced with, Lord, if I know that your lordship doesn't have the jurisdiction to take up a matter, will I come and move it? As per my understanding, arbitrator cannot grant me. Let me show that to your lordships. If my lord is of the view, despite that I should go, I'll go back.
Let this decision
Lord, let me
taken
place
by
it.
the arbitrator.
May I just say one thing? Since he is not here, let us not do it in piecemeal. Give me one date at 2 p.m. I'll finish it. Then my lord passes the order. Any day, whenever my lord sees.
2 p.m.
diary
that
দেখো
guy
না।
30th
11th
July.
Lord, 11th.
No, on this, all 2 p.m. fixed. I can
3 p.m.
I can remember
11th 3 p.m.
3 p.m. in this way.
শেষ হয়ে যায় থাক না বেশি টাইম নেব না আমি থাক let it be at 3 p.m.
No, I am to accommodate 2 p.m.
ডায়েরিটা দেখো
One 2 p.m. matter, second 2 p.m. matter, third 2 p.m. matter. In this way,
As per your
I have been forced to.
Lord, what I am asking, my lord, if one day is fixed, I can give them a notice, bring all of them and finish it off. Because the gentleman is coming every day.
And all there are big matters. It is not that short motion. It is all hearing matter. So it will take time.
1 2 p.m. is there on 11th.
11 2 p.m. কোথায়?
Diary
কি ডায়েরি দেখছেন আপনি?
11th 1 2 p.m. is there. 11 তারিখ এই শুক্রবার পরে শুক্রবার।
Okay, come it will be at second 2 p.m. matter.
Kindly pass an order to the patient.
Stop. आपने लिखो. Had the learned advocate. Arbitrator did not declare that I have no power.
No, that's all right. But if we interpret the
So
law,
whether the issue, this decision would be premature at this stage. In your case,
No,
it
that
has
I
not been.
understand. That I
There is no settled judgment and authority that no arbitrator is devoid of such power.
I have not
Okay,
shown that.
so it would be premature.
I have not
think.
shown that section. I will show that.
20F6 is clear, my lord, Railways Act. The power enforcement is given to the arbitrator.
I will argue on 11th. চলো এবার চলো আজকে তো হলো না চলো 11th I will try to settle.
Okay, next.
Budget number 6.
6. Yes. Who is your other side?
The last occasion also they remain absent. Possibly they are agreeable to us so far our claim is concerned. That is why. My lord, this is a case relating to a gentleman who superannuated as, my lord, the finance officer of Bardhaman University. Petitioner hearing. My lord, prior to, my lord, entering into the Bardhaman University service, she was, my lord, my lord, employee of Principal Accountant General of Central Government. In the year 1981, he inducted there. And in the year, my lord, 1999, he received one offer from the Bardhaman Vishwavidyalaya to be their audit and accounts officer. Lordship, kindly see page 30. 18/3/1999. My lord, the dispute over here is, my lord, whether this is re-employment or fresh appointment. Whether this is re-employment or fresh employment. Our humble submission before this honorable court, it is fresh employment. It cannot be treated as re-employment. That is the whole dispute, and they are disagreeing with us.
You want
Fresh appointment.
your appointment shall be considered as a fresh appointment.
Kindly see, my lord, page 30 will, my lord, speaks for itself. Page 30, my lord, annexure P1. My lord, addressed, my lord, from the registrar's office to, my lord, Parthananand Ghosh, writ petitioner herein. With reference to your application for the post of audit and accounts officer in the University of Bardhaman, I am to inform you that you have been selected for appointment to the post on the following terms and conditions. Your appointment will be on probation. So, my lord, in case of fresh appointment, there is a question of probation, 1 year, 2 year, deemed confirmation by the Executive Council, and all this question will only arise when the fresh appointment has been made. Here they have been used this term probation for a period of 1 year from the date of joining. Your starting pay.
Mr. Shahnas Tariq Mina is appearing for the state in this matter. He is on his legs in court number 4. But you'll also have the instruction to pay for not this week because he is yet to receive certain instruction from. He is yet to receive certain instruction from the authority. Your lordship, I have been instructed to pay for not this week.
It is for state, my lord. The principal respondent is Bardhaman Vishwavidyalaya. State, my lord, several communications are made. Mostly state is in favor of mine.
Who is appearing on behalf of
my lord, the order.
Bardhaman?
You will find, my lord, from the.
Respondent number 2 and 3. Who is respondent number 2 and 3?
Respondent number 2 and 3. My lord.
Who are respondent number 2 and 3?
My lord, University of Bardhaman, 3, my lord, being represented by the registrar.
That means Mr. Suman Bosu.
Mr. Shahnas Tariq Mina, I am praying for.
State.
It is for the state. Although ultimately state will release the fund.
True, but they are the local authority, self-governing authority, my lord.
So the person who will give money, he is the main authority.
State
nowadays.
At the same time, my lord, they have their own income also, my lord.
At this stage, the person who will give money, he is the main authority.
True, my lord. At the same time, university has their own income.
So you give a notice, and I am fixing a date. So he will be able to know the next date, and you give a notice to Mr. Bosu. Suman Bosu. আপনি এটা লিখুন। Had the learned advocate appearing for the respective parties list the matter ফাঁকা যদি না আছে একটু দিয়ে দিন। 10th হবে এত তাড়াতাড়ি হবে? আচ্ছা 10th July. 10th July. Petitioner is directed to intimate this order to the learned advocate who entered appearance on behalf of respondent number 2 and 3.
At the same time, allow me, my lord, to communicate register.
Huh?
At the same time, allow me, my lord, to communicate this order to the register of the...
Yes, intimate. কি বললাম? Intimate this order, yes. Yes, yes. Or intimate the next date of hearing, তাহলেই তো হলো। Intimate this order. Yes, next.
Number 7, I am for the petitioner. This is the matter. The petitioner, he is a widow. She is a widow, lordship. And the husband of the petitioner is engaged as a assistant teacher, lordship. I am led by Mr. Shivaji.
My lord, admittedly, the husband of this petitioner, my lord, he was an assistant teacher in a school. 1963, he was appointed. 1965, services approved. My lord, he worked for GAIN, my lord, for almost 17 years in that school. 1980, he died. My lord, the wife, this petitioner, is also an assistant teacher in a school. My lord, there was a delay. My lord, I do not say that there is no delay. My lord, the wife in 2021 made an application for grant of, my lord, family pension. Yes. Now, my lord, kindly comes to my lord, page 66.
62.
My lord, 66.
66.
Now, my lord, we made an application under the RTI Act before the school authorities. Now, my lord, in response to our RTI, my lord, application, now the school authorities say that with due respect, I beg to inform you that the information which has been asked by the incumbent as per RTI Act 2005 is an information about 41 years back. And when the RTI has not been enforced, so it is not possible for me to give satisfactory answers of these queries due to lack of sufficient information. Moreover, before enactment of RTI in 2005, most probably school authority had no idea that any information like the one as mentioned in the present context may be needed to supply to the stakeholder after a long gap of 40 years. In addition to that, the wooden furniture in which important documents were kept have been damaged to some extent by the termite due to long period closure of school for COVID-19 pandemic, and they have lost a general diary. Now, my lord, this is a reply dated 9th of November 2021. Now, the next page, lordship would see the general diary was just, my lord, 3 months prior to it. That in June 2021, the Almira, which contained the documents with regard to the service of this petitioner, were eaten away by termite, and they have lost a general diary. Now, my lord, we preferred an appeal against this order before the appellate authority. Now, my lord, before the appellate authority, hearing took place. Now, my lord, kindly comes to the last page of your lordship's brief, page 83. Now they have found everything, my lord, from the stomach of the termite. Now, my lord, kindly sees what they have found.
Yes.
With due respect, it is being informed to you by the undersigned that the information which has been asked by you as per RTI Act regarding documents of deceased HON'BLE Krishna Das as per decision adopted by DI of schools AC North 24 Parganas on the basis of the hearing, I am sending here with the following documents which are available in our school. Memo number regarding sanction of additional post, then approval of appointment, my lord, then again another approval of appointment, and the school acquittance roll. So, my lord, my case is anyhow, my lord, this lady is entitled to pension. There is no dispute of her deceased husband. There is a delay, my lord, admittedly a fault on her part. I do not stand in the way, my lord, but better late than never, my lord. She has made a claim. They have found the documents. Let them process and give the pension to the
Husband died in
1980.
You are appealing for?
But appearing for the state, my lord, led by Mr. Vishwabroto Basu Mollik, my lord.
Ah.
In previous occasion, Justice Sougata Bhattacharya please to direct, my lord, to file an affidavit of an opposition, my lord. So, my lord, we are.
You hand over the copy?
No, my lord.
Oh, wow.
My lord, right.
So you,
I will hand it over, my lord.
you take his or file reply?
Yes, my lord.
The only thing is, my lord, my lord, what I was only, my lord, beseeching your lordships. Now, my lord, this lady, my lord, Nirupama, my lord, she is presently, my lord, aged about 80 years. Now, my lord, if we go into this, my lord, affidavits, my lord, filing a reply and all, it will take some time. Now, my lord, admittedly from page 83, the DI has found the documents. Let the DI take a decision within a stipulated period of time and say whether they can grant her family pension so that she can see the light of pension during her, my lord, days. And I am told, my lord, she is completely bedridden now. Let the DI, my lord, based on page 83, they have found the documents. The documents, my lord, have been forwarded. My lord, the headmaster admits that I have found the documents. With these documents, my lord, there cannot be anything more. Now, my lord, let the headmaster, my lord, forward it to the DI. Let the DI take a decision within a specified period of time and grant her family pension. Along with, my lord, anything which she is entitled to.
This already in CCN, come to page 22 of their affidavit in opposition.
22. Annexure R5, my lord.
Headmaster has been asked to produce photocopies of those to the appellant within 7 days from the date of receipt of this order.
Yes. Let them take a decision. My lord, there is no point in keeping this petition pending here. She is already 80.
Take decision.
Take a decision within one lord, a stipulated period of time and one lord grants her family pension.
আসুন an octogenarian কি বলে Already taken on record. Don't worry. Yes. হ্যাঁ, আর হবে
হ্যাঁ, যদিও
Dispose of করুন।
ওকে ডাকুন কয়েকটা ডাকুন
মানে item number 8 to মানে 24 মানে we are appearing on behalf of the state as per
State,
হ্যাঁ,
petitioner is not there.
মানে all matters are relating to মানে the from the year 1990 to 96 my lord, and no service has been effected. My lord, Lanet PP has requested us to
Notice was also issued upon the state through the office of the notice could not be served upon the petitioner Dulal Chandra Barma as the petitioner already expired. No death certificate of the petitioner has been annexed with the record. Family report. Family members of the petitioner refused to sign on the paper.
মানে probably my lord, the first one number 8 item is a complaint case my lord. Item number 8 probably my lord, it's a complaint case my lord.
Complaint case. Yeah, item number 8.
মানে 8 to 24 my lord. Lanet PP has requested us my lord to appear before your lordship and to take care of all these matters my lord. Myself with my Joydeep Rai.
So what can be done? So dismiss for default. Let them come. Huh?
Not to dismiss the matter, my lord.
I know there is a judgment and such, but petitioner has died. Notice has been sent. The petitioner's family member refused to sign. I mean, refused to sign on the paper. Administrative notice was given.
No,
Then what can be? In connection with what? Any criminal case? Any criminal case?
All are criminal revision petition. my lord.
Criminal case against Dulal Chandra Bombo. So the case has abated.
My lord may do one thing, my lord. My lord may direct, we will collect all the police station case number. My lord may direct the police station to inquire about the, my lord, the status of the petitioners in all the cases. In first cases, my lord have already gone through the, my lord, the petitioner number.
It is 125.
Oh, it's a complaint case, my lord. That is not our, state has no role, my lord. Regarding, my lord, others, which are not the complaint case, my lord may direct.
If the petitioner died, 125 will also go.
And in respect of, my lord, the 125 case, that the state has no role to play.
State has no role. And petitioner has died. Another criminal case, most probably 480, did our 498 file appearing to be a matrimonial dispute. For other গুলো কি সব কি দুলাল বোম্ব নাকি? No. Oh.
Noor Islam Bislam.
So here you will not be able to say as to whether 125 proceeding is still alive or not. 83 cases of 83. If the
2014 matter, I think there is none. In fact, yes. I think all the matters, paucity of time, matter has not been heard. In fact, yes.
No, here husband died.
Husband died.
It is against Dulal Chandra Bombo. Annapurna Bombo filed an application under section 125. Now Dulal Chandra Bombo died. Already expired as indicated in the report of the assistant registrar. Then what proceeding?
Infectious, my lord.
in item 8, my 8 is my the 125 proceedings and state has no role.
Yeah,
That is my 8 to 24. My other cases except my the 125 proceedings, which are the GR cases, my lord may ask a report from the through.
Okay, one by one, allow the court apply its mind one by one. And it is 125 proceedings. Husband already died. ঠিক আছে, আমি
State has also no role to play.
আচ্ছা, challenging an order passed in a proceedings under section 125 of the Code of Criminal Procedure, the petitioner slash husband tomorrow, no, come on Monday.
Monday.
Let the
matter will be taken up at
after recess. এই 2 p.m. আছে? অরিজিনাল সাইড যারা তাহলে কি করবো এটা? তাহলে কালকে দিয়ে দেবো?
Chakaji are always good man.
হ্যাঁ,
Chakaji are always good man.
কালকে. So come tomorrow.
Tomorrow at 2 p.m.
At 2 p.m. 2 p.m. we will not all are booked. Tomorrow it will appear. Don't এটা উপরের দিকেই দিয়ে দেবেন তাহলে। আর হ্যাঁ কোন
mentioning next two matters, 26 and 27. And for the petitioner, I have instruction to withdraw the matters. Get them dismissed. The petitioner is no longer willing to proceed with the revision.
Have you got the revision? আরে নিন সবচেয়ে ভালো প্লেয়ার। আচ্ছা, your name please? আচ্ছা, eleven 2 p.m.
On 11th.
হ্যাঁ,
Can I give the name of mine, my lord?
और बट ये थाल तो So I am to change the order. I have observed in open court that your respondent number such and such are unrepresented, and hence I have given direction upon the petitioner you would intimate this order
Okay, my lord.
that
I
the
was-
matter will appear on such and such.
I got it.
Okay.
Intimate him right now in front of your lordship.
Yes, your lord.
So Mr. Bandyopadhyay is there.
Yes, Mr. Bandyopadhyay.
You will not guess today's appearance speak. Okay, done. Either I have to recall order, I have to record that hard all.
Your lordship thinks out fit, that can be
Huh?
given. Whatever your lordship thinks out fit is to be given, my lord.
You inform. আপনি ওইটা ইয়ে করে দেবেন তো। You inform Mr. Bandyopadhyay. Both of you inform Mr. Bandyopadhyay that I have recorded. Okay.
My lord is
There is a
recording.
judgment I can. আপনি লিখেন hard.
My lord may record that hard.
Other learned advocate appealing for the respective parties leaves the matter for further consideration on 11th
11th at 2 p.m.
At 2 p.m. ঠিক আছে? Your item number 7 or 5? 5.
পাঁচটাতে জজ সাহেব রেকর্ড করেছেন যে ও ছিল না, এখন বলছেন সবাইকে শুনে।
You inform Mr. Bandyopadhyay. Mr. Bandyopadhyay inform.
Why would he miss his fees?
Firstটাও তো সেম নাকি? ফার্স্টটাও তো সেম। ও সিমিলার ম্যাটার ফার্স্টটা। হুম, সেম ম্যাটার। ও ইয়েস, আমি দেখছি। হ্যাঁ, ইয়েস।
May I, my lords, kindly to mention two hearing matters of 2024 affidavits are complete.
Oh.
Affidavits complete, my lord.
Oh, monthly list দিয়ে দিন। Monthly list, হ্যাঁ।
Another extreme compulsion, my lord, may I be permitted to mention an appellate side matter? And your lordship is not taking up appellate side matters. I understand today there is a 3:30, my lord. So chances of your lordship reaching, my lord, that is why I'm mentioning, my lord. Your lordship will remember I was doing a matter with your lordship just before the vacations, my lord, with regard to the port trust. If your lordship remembers, my lord.
Port trust matter.
Yes, your lordship had recalled that order which was passed, my lord. Mr. Shah saying that the recording was not correct and something of that sort, my lord. But I was only.
Oh, that matter. It's a Pathad matter.
Yes, my lord. 2 p.m. fixed. It is marked 2 p.m. today, but since, my lord, your lordship has
today
is marked. But, my lord, I don't think it will reach because there are already 29 matters on the original side, I believe, my lord.
Okay, it will retain its position. Even the endorsement 2 p.m. also will be.
My lord, then we will, my lord, 2 p.m. again, my lord, with humility, I say that is why I'm here, my lord. If it can be marked 1 p.m., I'll point out why, my lord. Tomorrow, my lord, we have come to learn that there is a chance of a pen down from 2 p.m. my lord. So many problems, so many. So if you
1 p.m. within 15 to 30 minutes.
My lord, yes, I think so, my lord. It will be done. I don't think it will be a problem. I think, my lord, because, my lord, I will propose a proposal. If they are agreeable, I think that will get it through, my lord. So kindly keep it at 1. If it is not finished, my lord, then it will go to the next one.
Advocate General is there. Other side, most probably.
No, not this one, my lord. Here, my lord, Mr. Jishnu Shaha was on the other side, my lord.
Oh,
Your lordship remembers
yes,
that-
Jishnu Shah.
Yes, my lord.
Jishnu Shah. So you have to give.
My lord, I have given notice.
My lord, we are appearing for the port, my lord. My lord, if your lordship fixes a time, we don't have a problem.
Now, whether 15 minutes will be.
I think so, my lord.
So, my lord.
Huh?
Possibly so, yes. Yes, your lordship.
Kindly keeps it, my lord. I think proposal will fall from me. I think it will be acceptable, my lord.
Okay, এটা কোথায় গেল? 1 p.m. এটা করে দিন। Which matter? Item number?
210, my lord.
210.
2 p.m. mark, my lord.
এটা কালকে 1 p.m. করে দেবেন। দেখি।
Very grateful, very grateful.
হ্যাঁ।
Very grateful.
Okay. Yes.
Grateful. Sorry, my lord, I mentioned that appellate side matter.
Okay. Mr. Bhattacharya, item number 1 and 2 are the same.
Not same, but similarly. Not same.
Take some time. The final hearing stage. Kindly, my lord, allow me, my lord, to file my affidavit in opposition on behalf of High Court Administration.
And this is my reply.
Okay, I am releasing both the matter due to some personal reasons.
Personal reason.
Okay, I am releasing this matter. Okay.
Kindly record that the affidavits are filed.
Affidavits keep it since I am really going to release.
My lord, in item number 2, I appear for the High Court Administration. There was a direction.
Difficulty.
There was a direction to file a report in the form of an affidavit. And 12th of June was the last date. 11th of June, we have filed it in the department. I believe the records have come.
Okay, আপনি এটা লিখে দিন তো।
Both the matters.
Both the matter similar matter, most probably almost
similar,
similar.
not similar. Not similar. We are seeking, my lord, we are seeking something which is there in the High Court rules. Kindly have a look to the writ petition once. Command Aketta, my lord, in item number 1, my lord, the petitioner is pressing for, my lord, appointment in a vacancy which was there, my lord, and my lord, I am covered by the High Court rules. If your lordship kindly have a look, please go to the. My lord, if my lord has personal difficulty, I will not.
Yes, I am reviewing the matter stand release purpose 1 and 2 stand release from my list due to দুইটা আছে রেকর্ডে রিপোর্ট হ্যাঁ হ্যাঁ ইয়েস
দেখি ফাইলটা দেখি আমি
না না যশব নিচ্ছেন না তো আর কি হবে
আগে রিপোর্টটা আছে কিনা দেখি
ওকে আপনি এক কাজ করুন শুনুন উনি রিপোর্ট জমা দিয়েছেন ডিপার্টমেন্টে আপনি সেটা এনে রেকর্ডে ট্যাগ করে দেবেন
11ই জুন জমা হয়েছে ওটা রেকুইজিশন করে নেবেন
হ্যাঁ 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 রেকর্ডে এনে ট্যাগ করে দেবেন ওকে নেক্সট আইটেম নাম্বার 3
অঞ্চল ভট্টাচার্য
ইয়েস
I appear for the petitioner, my lord.
Lordship, I'm appearing for the respondent bank. I'm being led by Mr. Rupa Ghosh. He's on his way, my lord. The petitioners may continue till then.
May I start?
Okay, let him place his
Yes,
case.
yes,
You
your lordship.
take down note. Oh. One minute, let him place.
Your lordship will kindly have the writ once, please, my lord, the writ petition. And I'll briefly tell your lordship what the facts are.
Okay, I'm coming.
Opposition नहीं देगा ना? Fine. Opposition reply. May I briefly tell your lordship what the facts are, and then I'll trouble your lordship through the papers, my lord.
Yes, yes.
My lord, I believe the opposition and reply have also been filed. Now, my lord, my client, Asha Expo and Company Limited,
Value of commercial invoice presented for payment under letter of credit.
May I tell your lordship the facts, my lord? Summarize it, and then your lordship, I'll trouble.
Yes, yes.
My lord, my client is a company incorporated in the United Kingdom. It entered into a contract with an Indian entity in Calcutta, by which my client was to supply steel scrap to the Indian entity. Payment for that items was to be made by my lord UCO Bank, who is the respondent, sole respondent, by means of a letter of credit. My lord, the letter of credit was opened by UCO Bank in my client's favor. Under the letter of credit, my lord, my client deposited the documents, because the letter of credit, as your lordship knows, my lord, is a banking instrument which one bank, it's something like a bank guarantee. The only difference being it is used for international transactions. And unlike a bank guarantee, the letter of credit payment becomes liability arises when the documents are submitted. So once the letter of credit states out, my lord, that these are 10 documents which are to be submitted. Once I submit those 10 documents, then my lord, the bank, the letter of credit issuing bank, it is called, is obligated to make payment to me. It takes those documents, gives it to its client, who is the Indian importer. With those documents, the Indian importer gets delivery of the goods, because these are goods shipped by sea, by vessels. So there are bills of lading and there are other commercial documents which are there. So my lord, the letter of credit constitutes, my lord, an independent contract between the letter of credit opening bank and the beneficiary, who is the petitioner before your lordship, the foreign seller. Now, in this case, my lord, the letter of credit is also governed by a contract. The letter of credit is a contract. The terms and conditions of that contract are recorded in the Uniform Customs and Practices for Documentary Credits 500, which is also written in the letter of credit. It incorporates. So it does not set out the full terms of the main parent contract. It sets out that this letter of credit is governed by UCP 500. So that means, my lord, how the parties are to deal with this letter of credit is stipulated in UCP 500. Now, there are numerous judgments of the Supreme Court, my lord, which have dealt with letters of credit, the absolute liability of the bank who issues the letter of credit, and how the letter of credit is to be dealt with. It is settled law, my lord. There is nothing which is left to be decided in this, how the letters of credit are dealt with. The Supreme Court has time and again held that in following the international law, because this is, my lord, international law which is developed, which is also applied in India, because this is uniform. That is why it's called Uniform Customs and Practice. And it is framed by the UNCITRAL, the United Nations Committee for International Trade and Relations that frames this, which all countries adopt. So India has also adopted. So, my lord, following the international judgments, the foreign judgments, our Supreme Court has also held, and I'll trouble your lordship with those decisions, that the letter of credit constitutes an independent contract between the banker and the beneficiary of the letter of credit, who is to receive payment. The bank owes an absolute obligation to pay the money under the letter of credit to the beneficiary. All that the bank is concerned with is the documents which are stipulated in the letter of credit. Once it receives those conforming documents, it must release payment. If it has to object on any of the, if it has raised any objection that it is not to make any payment, it has to raise these objections within 5 working days of receipt of the documents. If the bank does not raise objection on any document within 5 banking days, then it assumes full liability to pay. After 5 working days, it cannot raise any objection that, look here, you were supposed to give document ABC, you have only given A and B, you have not given C. Or you were to give ABC, which has these details, this document does not have these details. So after 5 banking days, you are stopped from raising any objection on the correctness of the document. Then the bank has to make payment. This is now the settled law. Now in this case, my lord, the petitioner submitted the documents. There were 2 letters of credit opened by UCO Bank. Importer was the same. Petitioner submitted documents under both letter of credit. 1 letter of credit was duly paid. No difficulty. UCO Bank made payment under 1 letter of credit. Under the 2nd letter of credit, my lord, UCO Bank released the documents to the buyer. Buyer went with the documents to the shipping company to change the document. The bill of lading, my lord, now bill of lading is one of the documents which is given under the letter of credit. So bill of lading, my lord, is a shipping document by which the shipping company gives as a receipt. It's like the consignee note. We have a lorry challan, railway receipt. So when we get dispatch goods by lorries, my lord, we get a lorry challan, we get a railway receipt when we put goods on the trains. So when we put goods on a vessel, we get what is called a bill of lading, which is a receipt which says that yes, these so many goods have been put on the vessel, and this is the port of loading, and this is the port where the goods will be discharged, and this is the person who's entitled to delivery. So now the buyer here wanted the bill of lading to be shifted to some other name. So he wrote to us saying, I want some change in the bill of lading. We said, no difficulty. All the bills of lading are now with the bank. So you need to take these bills of lading, go to the shipping company, surrender these bills of lading, and take whatever new bills of lading you want. Buyer said, we will do that. We arrange for that. The petitioner arranged for that with the shipping company. Shipping company also said, there's no difficulty. I will take the old bills of lading, I will cancel them, and I will give you the new bills of lading. So the buyer now takes delivery of these documents from the bank, goes to the shipping company to change the documents. Then, my lord, he has a change of mind. He returns all these documents to the bank. He does not take delivery of the goods. After the bank has already released the documents to the buyer and more than 5 days have lapsed, the bank says, I will not make payment. Because the bank's client, who is the buyer, refuses to make payment and refuses to take up the documents. And for that actual reason, the bank refuses to make payment under the letter of credit. Now, whatever it is between the bank, my lord, and its buyer and its client, who is my buyer, that whatever they have disputes, they don't have disputes, whatever disputes there may be between the buyer and me, that does not absolve the bank from making payment. Bank's contract with me is an independent contract. I have discharged the contract by giving the bank the documents. Bank sees the documents. If it doesn't raise an objection within 5 days, it is bound to make payment. After more than a month, bank says, I will not make payment. That is now, my lord, what is under challenge before your lordships in this writ petition, only for directions upon the bank that the letter of credit obligation must be performed. There is an issue always, my lord, in writ petition. The state respondent always takes the issue of maintainability, that this involves disputed questions of fact and law. So the writ court will not intervene. Now I have a single bench decision of our court in the case of a bank guarantee matter, where our court said refusal to make payment under the bank guarantee is equal to refusal to make payment under a letter of credit. So letter of credit stands on a higher footing than even a bank guarantee. The absolute obligation which is owed by the bank to the recipient or the beneficiary of the letter of to the bank guarantee stands at a lesser footing than a letter of credit. So our court has held, single bench affirmed by division bench, SLP dismissed by Supreme Court. The writ petition filed to enforce a payment under a bank guarantee which the bank was wrongfully refusing to pay, writ petition is maintainable. And not only that, our court, my lord, directed action to be taken against the erring officials of the bank, which was affirmed by the division bench. Payment was directed to be released with monies. And our court said that this bank guarantee is similar to a letter of credit. In other words, implying that it stands on as high a pedestal as a letter of credit. So for bank guarantee payment, our court has allowed in writ jurisdiction, my lord, then a letter of credit payment definitely, my lord, can be entertained. Number one. And I'll show those judgments, my lord. Second is, my lord, the Supreme Court has also held that in contractual matters, where there is arbitrariness and perversity and capricious conduct on the part of the state authorities, the writ court can intervene. It can even intervene if there are disputed questions of fact. Just because there's a disputed question of fact does not mean that you will send him to the alternate remedy. If on paper the dispute seems to be fictitious and bogus and just a device to avoid making payment, then writ court can definitely interfere in contractual matters. There is, my lord, a very current judgment of the Supreme Court on this also. So these are the basic two, my lord, arguments on maintainability which they raise. The third argument on maintainability which they raise, now the argument on merit which they raise is that, look here, I did not complain of the documents being defective within 5 days, admitted position. But when you sent the documents, that is when my bank sent the documents to him, you already said that the documents are defective. So I was not required to complain again. Lordship, follow what I'm saying. See the ingenious argument. He says that the documents which you sent to me, you yourself admitted that the documents are defective. Therefore, I was not required to raise any dispute about the defectiveness of documents in 5 days. Therefore, I did not raise any dispute in 5 days, admitted position, because you yourself admitted that the documents are defective. Now, I will show your lordship from the documents that A, there is no such admission on my bank's part, that is State Bank of India, London, that the documents were defective. Number two, even if documents were defective, under the UCP, he is required to record that defect within 5 days, which if he does not do, then does not absolve him of liability. Number three, defect, if any, assuming but not admitting that there was a defect in the document and you did not raise it within 5 days, you have waived those defects because you released the documents to the buyer. If the documents were defective, you should have returned the documents to me. You should have recorded a protest that these documents are defective, but you have released those documents to your buyer so that the buyer can take delivery on the basis of those documents, which he could not have without making payment to me. That is why, Malad, this whole letter of credit, when I show your lordship these judgments, the letter of credit has evolved as a mechanism when two parties, Malad, sitting in foreign countries who don't know each other, who negotiate for the sale of goods, but they don't know each other. They don't trust each other as to whether if I send the goods to him, whether he'll make payment or not. So that payment is now secured by means of a letter of credit from a bank. So, Malad, once I send the documents, the bank gets the documents, bank becomes liable to make payment. You leave the buyer aside because you don't trust the buyer, you trust the bank. You are supplying goods on the credit of the bank. That is why it's called letter of credit. The bank puts its liability that I will pay for the goods. You give me these 10 documents, I will pay for the goods. Now, when the bank receives, that is why when the bank receives the documents and the documents are not in order, bank is obligated to complain immediately. These documents are not in order. I am no longer liable. I am no longer liable. I am putting you on notice the documents are not in order. What the bank does in this case is it releases these so-called defective documents to its buyer to take delivery of the goods. So any defect, if any, in the documents stood waived by the bank by releasing the documents to the buyer. But we did not go thus far. This I am only telling your lordship to show the malafide of the bank. This contention which it raises that the documents were defective is wholly malafide. If the documents were defective, why did you release it to your buyer? If you release it to your buyer, that means you've admitted your liability to make payment, because you could not have given it to the buyer without first making payment to me. So this document shows the absolutely malafide conduct of a nationalized bank. He's playing fraud on a foreign entity and bringing disrepute to all banks in India, because this has ripple effects. And that is why State Bank of India has repeatedly written letters to them. State Bank of India, London, who was my banker, has repeatedly written letters to UCO Bank that what you are doing is wrong. You make payment. Yet they don't make payment because they want to protect their buyer. This is, my lord, their defense and my answer. Now, my lord, may I show your lordship the documents? Kindly have first, my lord, the letter of credit. Kindly come to, my lord.
Thakkar conclude today. Kindly gives me 1 day's time because I was not aware the matter is going to come up today. Mr. Thakkar should conclude. I can come and return tomorrow. Today I won't be. My argument.
I leave it, my lord. I leave it to your lordship, my lord. Your lordship can hear me today, or your lordship can hear both of us.
Conclude today.
I will try. My lord, kindly come to page 19, please, my lord.
Page 19. Yes, I am on page 19.
Now, my lord, this is the letter of credit. This document is the letter of credit. Now, my lord, this document is, your lordship will kindly see format, about 5-6 lines from the top. Your lordship sees format over there, about 6 lines. Under the, your lordship sees in bold message header. On the left.
What format?
Yes. Under message header, your lordship sees.
Header, yes, format.
Format
Swift.
Swift. Now, my lord, Swift. Swift is an abbreviation, my lord.
Yes.
Swift, SWIFT, is an abbreviation and an acronym. It stands, my lord, for society. The S stands for society. For worldwide. W stands for worldwide. I stands for internet, interbank. F stands for financial. And T stands for telecommunication.
F stands for?
Financial.
Financial.
And T, my lord, stands for telecommunications.
Yes.
So, my lord, when banks in different countries, are sending communications to each other, this is, my lord, a society which is there, in which all banks are members, and they frame a format for uniform communication. So if I write this is, it's like a code, my lord. I just write 4 letters. These 4 letters mean this in the code. So that is why, my lord, instead of long details, they don't give long details. That is why now, if your lordship now kindly sees, kindly come to, on just after message text, your lordship sees F27.
Yes.
F40A. Now, these are called fields. These numbers on the left, we would call them serial numbers, but these are referred to as fields. Now, each of these fields, my lord, is in a format. So, F27, for example, means sequence of total, number 1, total 1. Then your lordship sees field 40A, form of documentary credit, irrevocable. So, once given, it cannot be revoked. It's an irrevocable documentary credit. Then your lordship kindly sees what I told your lordship, UCP, kindly see field 40E, applicable rules.
Yes.
Your lordship has applicable rules. Applicable rules, UCP latest version. UCP stands for Uniform Code and Practice for Documentary Credits. That is the, my lord, full form of UCP. So the rules which govern this document are the UCP. Now your lordship kindly sees the amount is mentioned. Currency is mentioned, my lord, 3,65,000 US dollars. Applicant bank, I'm sorry, my lord, I should have shown your lordship. Applicant bank. Your lordship sees applicant bank.
Ispat Udyog.
I'm sorry, no, my lord, that is the
applicant bank, UCO Bank.
UCO Bank. So, my lord, the applicant bank who has issued the letter of credit is UCO Bank India Exchange. At whose instance? At the instance of the applicant Ispat Udyog, who's the buyer. So, my lord, Ispat Udyog has an account with UCO Bank. On Ispat Udyog's request, UCO Bank issues the letter of credit. Then the amounts, and then your lordship kindly sees beneficiary.
Beneficiary is the Asha Expo.
Yes, he is, my lord, the petitioner before your lordship. So, my lord, at the request of the applicant Ispat Udyog, UCO Bank issues this letter of credit in favor of the beneficiary who's the petitioner. And then the amount is also mentioned. Your lordship will see US dollars 365,000. Then kindly turn over to the next page. Now, all these terms and conditions are given, my lord, of the letter of credit. As to what documents are required, kindly see, my lord, field 46A at page 20.
Yes, document required.
Document required. I am grateful, my lord. So now, my lord, it lists 11 documents which are required. So once I give these 11 documents, all that the bank does is it sees whether the documents tally with the description given here. So the Supreme Court has held, my lord, that a banker, when he opens a letter of credit, does not deal with the goods. He does not see the goods. He only sees the documents. If the documents given here are supplied to him by the beneficiary, he is obliged to pay. He is not concerned with the goods at all. All that he needs to see is whether there is a draft for 45 days or not. So when I submit the documents to him, whether there is a detailed packing list or not, whether there is a beneficiary signed commercial invoice in 4 original copies certifying these goods or not. So once the documents are there, the banker is obliged to pay. Whether the goods come or they don't come, whether the goods come with, supposing Malad, the document says the goods are steel scrap. The document says invoice saying steel scrap. Now the goods come is iron scrap. Bank cannot refuse to pay. Bank is only concerned with the document. If the document says steel scrap, bank will pay. If the goods come as iron scrap, it is for the buyer to fight it out with the seller. The bank is only concerned with the documents and nothing else. So your lordship sees there are 11 documents mentioned. Now my lord kindly turns over. All these things are there. Kindly see page 21 once, please, my lord. Serial 7. Minor spelling and typographical errors in documents. UCP.
Which do not change the meaning.
Which do not change the meaning or intended implication should not be considered a discrepancy, and all documents must be in English language. So if there are minor spelling or typographical errors, that will not make the document discrepant. Then, my lord, these are standard formats, my lord, which are there in all documents. Now, the terms of this document was amended, my lord, by an amendment, which your lordship will find at page 22.
Yes.
There is an amendment. I am not troubling your lordship with the amendment. Now, pages 23 onwards are the documents which I have given to the bank, some of the documents. Because it is nobody's case that didn't give the documents. Now, my lord, kindly come to page 28.
Yes.
This is a SWIFT message. SWIFT message now, my lord, sent by, your lordship will see, SWIFT sender. Your lordship sees in the middle of the page under message header. SWIFT sender, your lordship sees. SWIFT sender.
Yes.
SBI. SBI NBE 2XXX. This is the code for, my lord, State Bank of India, London. He is sending, this is like, my lord, earlier we used to have telex. There used to be numbers. Now these are alphanumeric. These are codes from which you understand to which bank and which branch.
IFC code.
Yes, IFC code like we have in our checks.
Yes.
Same.
Yes.
But now because this is same, this is like IFC code, my lord, but in an international context.
Yes.
SWIFT receiver is UCO. SWIFT receiver is, my lord, UCO Bank. Now, my lord, kindly come to the narrative. Kindly see. We have presented. We have presented documents for US dollars so much on 25th May 2018. Please read the amount as so and so. Please amend bill of exchange. Interest amount should read so and so. Please advise acceptance for USD so and so with due date of 9 July 2018. So, my lord, the documents were presented on 25th May 2018. Your Lordship sees the date.
Yes.
And he's saying, and this message, my Lord, is sent on 8 June
8 June. Yes.
28.
Hmm.
He says, you please give this acceptance by, you give this acceptance of these documents. Now, my Lord, I was telling your Lordship, UCP 600. Now, kindly have UCP 600 once, please, my Lord. Into Judge ke din. Sorry.
Yes.
UCP 600, your Lordship says. This is, my Lord, the ICC text introduction. I'm not troubling your Lordship with all the introduction which is there. Kindly come to page 4, where the UCP actually starts.
Yes.
Kindly see the application of the UCP. The Uniform Customs and Practice for Documentary Credits 2007 revision, ICC publication number 600, are rules that apply to any documentary credit, including to the extent which may be applicable under any standby letter of credit. We are concerned with an irrevocable. When the text of the credit, your Lordship kindly sees, when the text of the credit expressly indicates that it is subject to these rules. So here, my Lord, the letter of credit says UCP, latest version of UCP to supply. They are binding on all parties thereto unless expressly modified or excluded by the credit. Credit means, my Lord, the letter of credit. Now, kindly come to clause. Kindly give me a minute. Kindly come to Article 4, please, my Lord.
Article 4.
Yes. Kindly turn to page 5.
Yes, page 5.
Article 4. Credits versus contracts.
Yes.
This is what I was telling your Lordship, my Lord. A credit by its nature is a separate transaction from the sale or other contract on which it may be based. It's a totally different, independent contract. Banks are in no way concerned with or bound by such contract, even if any reference whatsoever to it is included in the credit. Consequently, the undertaking of a bank to honor, to negotiate, or to fulfill any other obligations under the credit is not subject to claims or defenses by the applicant resulting from its relationships with the issuing bank or the beneficiary. So, my Lord, banks undertaking to make payment on the letter of credit is not subject to any defense which its path can raise arising out of disputes with the bank or me. It's an independent contract. A beneficiary, similarly, my Lord, because it has to work both ways, a beneficiary can in no case avail itself of the contractual relationship existing between banks or between the applicant and the issuing bank. So I also stand out. I am only concerned with my contract, which is with the issuing bank. Whatever other relations they have, I cannot, my Lord, involve. Now, your Lordship kindly sees UCP Article 5. Documents versus goods, services or performance. This is what I was telling your Lordship, my Lord. Banks deal with documents and not with goods, services or performance to which the documents with relate. So, my Lord, here the bank is dealing only with the goods and nothing else. Now, your Lordship kindly turns to Article 7.
Yes.
Issuing banks undertaking. Provided that the stipulated documents are presented to the nominating bank or to the issuing bank. Here there's an issuing bank, my Lord, and that they constitute a complying presentation. The issuing bank must honor if the credit is availed by sight payment, deferred payment, whatever. So, my Lord, as long as the documents are complying, the bank must pay. It's an absolute obligation. Now, my Lord, kindly turn to, when I told your Lordship, the time limit for the
verification of the document.
Verification of the document. I'm so grateful, my Lord. Kindly come to Article 14. standard for examination of documents.
Yes.
A nominated bank acting on its nomination, a confirming bank if any, and the issuing bank. We are concerned with the issuing bank here. And the issuing bank must examine a presentation to determine on the basis of the documents alone whether or not the documents appear on their face to constitute a complying presentation. So that is the obligation of the bank, whether the documents institute a complying presentation or not, only on the face of the documents, nothing else. Then your Lordship kindly sees the time limit. B, a nominating bank acting on its nomination, a confirming bank if any. These two we are not concerned with. Malad, kindly see the next. And the issuing bank shall each have a maximum of 5 banking days. 5 banking days following the date of presentation to determine if a presentation is complying. This period is not curtailed or otherwise affected by the occurrence on or after the date of the presentation of any expiry or last date. So, my lord, 5 banking days he has to determine whether the presentation is compliant or not. Now, kindly see, my lord. Article 15, complying presentation. When an issuing bank determines that a presentation is complying, it must honor. Can you see the imperative words, my lord? It must honor. Then I'm not troubling your lordship with B and C, that those are not relevant. We are only concerned with issuing. Then kindly come to Article 16.
Yes.
When a nominating bank, kindly omit the first two, kindly start from or the issuing bank. Your lordship sees?
Yes.
Yes. The issuing bank determines that a presentation does not comply, it may refuse to honor or negotiate. So within that 5 days, if he sees that the document is not in accordance with the terms of the letter of credit, it may refuse to honor. Then kindly see what does he do when it refuses to honor. Kindly come to B. When an issuing bank determines that a presentation does not comply, it may, in its sole judgment, approach the applicant for a waiver of the discrepancies. Applicant being the buyer. So he tells the buyer that, look, you wanted these documents. These documents have come, but I find that one document is discrepant. Now it is up to you whether you will take it with the discrepancy or not. He can approach the buyer, applicant being his client, on whose request he is issued the letter of credit. Because the documents have been agreed by him. It is for his benefit that the document. So he can approach the buyer to waive any discrepancy. But all this, my lord, must be done within 5 days. This, kindly see, this makes it very clear. This does not, however, extend the period mentioned in sub-article 14B. That is a period of 5 days. So bank has a period of 5 days. In 5 days, it has to determine whether the discrepancy. In those 5 days, he can ask his client that, look, there's a discrepancy. Will you accept the document with the discrepancy or should I return it? If the buyer says, accept it with the discrepancy, there's no difficulty. Then the bank waives the discrepancy. Then it does not complain. If the buyer says, no, I don't accept this discrepancy. This is a discrepancy, you're right. I don't accept it. Then the bank can return the documents. So yes, this is a discrepancy. I am not obligated to accept it. My buyer is not accepting. I am not obligated. But all this, my lord, must be done within 5 days. Cannot extend this. Going to his buyer, coming back to me, all this cannot extend the time of 5 days. 5 days, my lord, time is critical. Then your lordship kindly sees C. Kindly come to the last part of that sentence, the issuing bank. Your lordship has that?
Yes.
The issuing bank decides. The issuing bank decides to refuse to honor or negotiate. It must give a single notice to that effect to the presenter. So, my lord, if UCO Bank says that the documents are discrepant, within 5 days, he has to give a notice to the presenter, here being, my lord, State Bank of India, London. who is presenting the documents on my behalf. That is not mentioned here because the banks change from time to time. In this case, the documents went, I gave the documents to State Bank of India, London. State Bank of India, London gave it to UCO Bank, because this is a negotiation between two banks, not between me and the bank. It is between my bank and the buyer's bank. So, my lord, he must give a single notice to State Bank of India, London, within 5 days if he refuses to name. And the notice must state, now, my lord, kindly see, what the notice must state is also given, that the bank is refusing to honor or negotiate each discrepancy in respect of which the bank refuses to honor or negotiate. So, my lord, it is not, you cannot just reject. You must reject with reasons in writing. And see that the bank is holding the documents pending further instructions from the presentor. So once he gives a notice of rejection, he can say that, okay, I'm holding on to the documents. You tell me what is to be done. If you're rectifying the documents, very good. I'll hold on to the documents. Or that the issuing bank is holding the documents until he receives a waiver from the applicant and agrees to accept it, or receives further instructions from the presenter prior to agreeing to accept such a waiver. So these are the options which are given. You reject in 5 days, but in that notice, you either say to the presenter that you please remove these defects, tell me what is to be done, or you say that I am asking my buyer whether he will accept or reject, but I am rejecting. If my buyer accepts it, we'll accept it. Third, he must return the documents. That is C. Says nothing, I'm returning the documents. I am not getting into any confusion. Or that the bank is acting in accordance with the instruction previously received from the processor. Now, my lord, kindly see D. The notice required in sub-article 16C must be given by telecommunication, or if that is not possible, by other expeditious means, no later than the close of the 5th banking day following the day of presentation. So again, 5 days. Repeated multiple times. That whatever you do, you must do in 5 days. 5 days is repeated multiple times to lay stress that the notice must also be given in 5 days of acceptance or rejection. Then kindly turn to F, which is very important, my lord. Kindly turn over. If an issuing bank fails to act in accordance with the provisions of this article, it shall be precluded from claiming that the documents do not constitute a complying presentation. Within 5 days, you don't give a notice in writing specifying which are the documents which are discrepant. After 5 days, you cannot take this objection at all. Your right to object is lost forever. Then kindly see next. Next is not important, my lord. It is on claim of interest. So, my lord, this is the absolute obligation of a letter of credit issuing bank under the UCP. Now, my lord, may I show your lordship, my lord, how the Supreme Court has interpreted these clauses. Kindly have the copy the. The first authority on this is 1988 1 SCC 174 in the matter of letter of credits. This is, my lord, the lead judgment of the Supreme Court. My lord, all subsequent judgments refer to this. And this was delivered by my lord Justice Sabyasachi Mukherjee, as his lordship then was, my lord. Now this, my lord, is a decision involving a bank guarantee. But here the Supreme Court says a bank guarantee is a simpler version of a letter of credit and stands on a lesser footing than a letter of credit. Kindly come to paragraph 4. In this case, my lord, an injunction was granted restraining invocation of a bank guarantee in a civil suit. The Supreme Court said it cannot be done. Kindly see paragraph 4. The contention of the appellant. Lordship has that, my lord?
Yes.
The contention of the appellant was that as per the terms and conditions of the contract bond, the respondent was to furnish a performance bank guarantee for rupees 16.5 lakhs and yet another bank guarantee for rupees 33 lakhs as security for the monies advanced by the appellant to the respondent for undertaking the work. Both these two guarantees, as also the contract bond, entitle the appellant to invoke them and call for their realization and encashment on the respondents failing to perform the obligations for which the appellant was made the sole judge. So, my lord, there were bank guarantees. Now, kindly come to 14, please, my lord.
Paragraph 14.
Yes, 14.
Yes.
I am, however, the High Court, my lord, restrained the invocation of the bank guarantee, against which the, my lord, beneficiary came up in appeal before the Supreme Court. Now, kindly see paragraph 14. I am, however, unable to agree. The principles upon which bank guarantees could be invoked or restrained are well settled. Our attention was also drawn to several decisions of the High Court as well as this court. Reference has also been made to some of the English decisions. So far as the position of English law is concerned, the principles by now are well settled. I will refer to some of the decisions and explain the position. Now, kindly see 15. The Supreme Court refers to a case of English court, my lord. In this, about 6 lines in that paragraph, my lord, your lordship will kindly see the letters of credit. So the English case which the Supreme Court refers to was a case of letters of credit. And then, my lord, if the English decision is noted with approval, kindly come to, my lord. It was held. Kindly see about 3 lines from the bottom. It was held. At that page, my lord, 3 lines from the bottom, sentence beginning,
It was held, yes.
Yes, it was held. Your lordship has that. It was held that although the court had wide jurisdiction to grant injunction, this was a case, not a case in which in the exercise of its jurisdiction it ought to do so. The Court of Appeal, now this is the history of letters of credit which the Supreme Court is approving. The Court of Appeal emphasized that an elaborate commercial system had been built up on the footing that a confirmed letter of credit constituted a bargain between the banker and the vendor of the goods, which imposed upon the banker an absolute obligation to pay, irrespective of any dispute there might be between the parties, whether or not the goods were up to the contract. The principle was that commercial trading must go on the solemn guarantee, either by the letter of credit or by bank guarantee, or irrespective of any dispute between contracting parties, whether or not the goods were up to the contract. The banks cannot be absolved of their responsibility to meet the obligations. Lord Jenkins, Law Justice, observed that a vendor of goods selling against a confirmed letter of credit was selling under the assurance that nothing would prevent it from receiving the price. That was of no mean advantage when goods manufactured in one country were sold in another. Though in this case, no international trade was involved. Now, the Supreme Court is talking about the case before it. Though in this case, no international trade was involved, bank guarantee was uninvocable and uninvocable, and on that assurance parties have bargained. The principle enunciated by Lord Justice Jenkins has been invoked by this court in some decisions of confirmed bank guarantees. So, my lord, letter of credit principles apply to bank guarantees also. That is why, my lord, and the whole history of letter of credit, the Supreme Court approves here. Why the letters of credit are of so much importance. Then 16, it refers to another decision of letter of credit. 17, again, decisions, my lord, of the English court are concerned. Now, my lord, kindly come to paragraph 19, please. 18. In my opinion, the aforesaid represents the correct state of law. So, my lord, the English decisions represent the correct state of law. Then kindly see paragraph 19. Another English case is noticed, which is on a letter of credit. Kindly see about 5 lines from the bottom.
Yes.
It was held by a bench. Your lordship has that? It was held by a bench consisting of Lord Denning, Master of Rolls, Brown and Geoffrey Lane, Lord Justice, that a performance guarantee was similar to a confirmed letter of credit. where therefore a bank had given a performance guarantee, it was required to honor the guarantee according to its terms and was not concerned whether either party to the contract which underlay the guarantee was in default. The only exception to that rule was where fraud by one of the parties to the underlying contract had been established and bank had notice of fraud. So the only defense which the bank can take is that there has been a fraud. That is the only exception, nothing else. Kindly see paragraph 21, please. My lord, what the Supreme Court holds. About 5-6 lines from the bottom. An irrevocable. Your lordship has that sentence beginning an irrevocable.
Yes.
An irrevocable commitment, either in the form of confirmed bank guarantee or irrevocable letter of credit, cannot be interfered with except in case of fraud or in the case of apprehension of irreversible injustice made out. This is the well-settled principle of the law in England. This is also a well-settled principle of law in India, as I shall presently notice from some of the decisions of the High Court and decisions of this court. So, my lord, when there is an irrevocable letter of credit, it has to be paid unless there's a case of fraud. Then kindly see 22. In the instant case, there was no fraud involved and no question of irretrievable justice was involved. Then kindly see 23 once, please, my lord. It refers to another decision of House of Lords. Kindly turn to page 187, where it was reiterated. Again, the Supreme Court, my lord, approves the significance of a letter of credit, my lord. Kindly see where it was reiterated. Where it was reiterated that the whole commercial purpose for which the system of confirmed irrevocable documentary credits had been developed in international trade was to give the seller of goods an assured right to be paid before he parted with control of the goods without risk of the payment being refused, reduced, or deferred because of a dispute with the buyer. So a letter of credit is opened, my lord, before I put my goods on the vessel. I am confirmed that if I ship these goods and I provide the documents to the bank under a letter of credit which the bank has opened, I will get payment. That is the whole purpose, my lord, of a letter of credit, and that is what is being sought to be frustrated by UCO Bank here, my lord. Kindly see, it followed that the contractual duty owed by an issuing or confirming bank to the buyer to honor the credit notified by him on presentation of apparently conforming documents by the seller was, now my lord, kindly see, was matched by a corresponding contractual liability on the part of the bank to the seller to pay to him the amount of the credit on presentation of the documents. The bank's duty to the seller was only vitiated if there was a fraud on the part of the seller. And the bank remained under a duty to pay the amount of the credit to the seller, even if the documents presented, although conforming on their face with the terms of a contract, nevertheless contained in a statement of material fact was not accurate. These principles must, in my opinion, apply in case of bank guarantees in internal trade within a country. So the principles of letter of credit, my lord, are borrowed to bank guarantees. Now, my lord, I'm not troubling your lordship with this. Kindly come to 29 once, please, my lord, where the Indian Supreme Court, our decision, my lord, is noticed now after noticing all the English decisions. In Tarapur and Company, Madras versus Mrs. V.O. Tractor Export, Moscow, this court observed that irrevocable letter of credit had a definite implication. It was independent of and unqualified by the contract of sale or other underlying transactions. It was a mechanism of great importance in international trade, and any interference with that mechanism was bound to have serious repercussions on the international trade of this country. The court reiterated that the autonomy of an irrevocable letter of credit was entitled to protection, and except in very exceptional circumstances, courts should not interfere with that autonomy. Similar, courts should not grant injunction because it is such an important document of trade and commerce. It has a bearing on the international trade of India, and therefore even courts should not interfere. Here, my lord, bank has not even gone to court. He has simply refused to pay. And the foreign seller, my lord, has now to approach your lordship and trouble your lordship with this. Then kindly come to paragraph 34, please, my lord. The court say we will also not interfere, my lord. Kindly see 34. On the basis of these principles, I reiterate that commitments of banks must be honored free of interference from courts. That's what that matter. And even a court will not restrain a bank from making payment, free from interference. Because all this, the Supreme Court is saying, because your Lordship has seen, the High Court had restrained payment. The Supreme Court is admonishing the High Court that you could not interfere with this. This is an absolute obligation to pay unless there's a case of fraud. Now, in this case, the bank has gone back on this absolute obligation. I have shipped the goods. The goods have come to Calcutta. I am out of pocket to the value of the goods. The bank refuses to make payment. So I am left high and dry, my lord. I have lost my goods, and now the bank is refusing to make payment. So this is how, my lord, the Supreme Court has dealt with, my lord, letters of credit. Kindly now come to just one more paragraph. I'm so sorry, my lord. Paragraph 45 once, please. I'm troubling your lordship with so much because this is the importance, my lord, of the letter of credit.
Yes.
The letter of credit. This is the, my lord, concurring judgment delivered by Justice Shetty. The letter of credit has been developed over hundreds of years of international trade. It was most commonly used in conjunction with the sale of goods between geographically distant parties. It was intended to facilitate the transfer of goods between distant and unfamiliar buyer and seller, like in this case, my lord. It was found difficult for the seller to rely upon the credit of an unknown customer. It was also found difficult for a buyer to pay for goods prior to their delivery. So that is where the balance is done, my lord. Buyer doesn't want to pay for the goods prior to delivery. Seller doesn't want to ship the goods. He's shipping the goods from London. He doesn't want to ship the goods prior to confirmation that he will be paid. And that is why this mechanism. The bank's letter of credit came into existence to bridge this gap. In such transactions, the seller, that is the beneficiary, receives payment from the issuing bank when he presents a demand as per terms of the document. The bank, my lord, kindly see, the bank must pay if the documents are in order and the terms of credit are satisfied. The bank, however, was not allowed to determine whether the seller had actually shipped the goods or whether the goods conform to the requirements of the contract. Kindly see what the Supreme Court is saying. Bank is not required to see whether the goods have been shipped or not. As long as the document says goods have been shipped, bank has to pay. Whether the document, if the document says steel scrap and the letter of credit says steel scrap, you pay. Marble might have come or dust might have come, but the bank cannot refuse to pay. So, my lord, any dispute between the buyer and the seller must be settled between themselves. The courts have, however, carved out an exception to this rule of absolute independence. The court has held that if there has been fraud in the transaction, the bank could dishonor beneficiary's demand for payment. The courts have generally permitted dishonor only on the fraud of the beneficiary, not for somebody else. So, my lord, only if there is fraud, then the bank can refuse to pay and the court will step in to restrain the bank from making payment. Only if there's a fraud. In this affidavit in opposition, your lordship will find that fraud is not even mentioned. There's no case of fraud. So the bank, my lord, in my respectful submission, owed an absolute obligation to make payments to me. Here also, my lord, the fraud angle has, the applicability of the UCP has been noticed. Kindly see paragraph 48, please, my lord. This was the precursor to the UCP, my lord. It was called the Uniform Commercial Code. The exception of fraud created in the above case has been codified in section so-and-so of the Uniform Commercial Code. This was, my lord, before UCP. There was an exception. Now the UCP does not have any. So, my lord, in this judgment, the Supreme Court has, my lord, specified the importance of, my lord, a letter of credit in banking transactions. Now, my lord, on this 5 days, bank cannot refuse to pay after 5 days. Your lordship will kindly have 2001 SCC 663.
Yes.
Kindly come to paragraph 5, please, my lord.
Paragraph 5?
Yes, paragraph 5 of this decision. Here, my lord, the Supreme Court discusses about the applicability of the UCP 600.
Yes.
As the case involves, your lordship has it?
Yes.
As the case involves issues relating to banking practice and interpretation of the Uniform Custom and Practice of Documentary Credits 1983, my lord, after that there have been several revisions, hereinafter called the UCP, issued by the International Chamber of Commerce, relied upon by the negotiating bank in detail, we propose to deal with the articles of UCP and their relevance.
Yes.
Now, kindly, the letter of credit in that case is set out. Now, kindly see the relevance, my lord, which the Supreme Court discusses. Kindly come to paragraph. Can you give me a minute, my lord? All the other English cases, I'm not troubling your lordship with because those which were referred to there are also referred to here. Kindly come to paragraph 34 once, please. Here also, my lord, the Supreme Court notices the importance of the UCP. This point mainly deals with the UCP code, which was incorporated by reference into the letter of credit, just like our case, my lord. As the interpretation of UCP is commercially of considerable importance, we would like to deal with the relevance of the UCP code in some detail. This court had occasion in United Commercial Bank versus Bank of India to refer to the UCP for short, by which the general provisions and definitions and the articles following are to apply to all documentary credits and binding upon unless otherwise agreed. UCP states that it shall be deemed incorporated into each documentary credit if there are words in the credit indicating that such credit was issued subject to the UCP. Then can you see 36? UCP has been formulated by the International Chamber of Commerce. Professor R.M. Good described it as the most successful harmonizing measure in the history of international commerce. Professor E.P. Ellinger stated that the UCP was the result of necessity and the need for use of banks as agents in international trade. The UCP was first drafted in so-and-so, so-and-so. It was revived. So, my lord, all the revisions of the UCP are noticed. Now, kindly see, my lord, so the Supreme Court is also in after that judgment of 88 in 2001, after so many years, again, my lord, the Supreme Court notices the importance of UCP. Kindly see, my lord, paragraph 38 now. We are here concerned. Your lordship has that one?
Yes, yes.
We are here concerned with the Uniform Commercial Practice of Documents 1983, which is referred to in the LC. It states in Article 3, credits by their nature are separate transactions from sale or other contracts. This I have shown your lordship the corresponding article in our case also. In the revision now, my lord, Article 3 is now Article, kindly give me a minute. Article 4. What your lordship saw, my lord, a credit by its nature is a separate transaction. What the Supreme Court is noticing, Article 3, in the latest UCP, it is Article 4. It's para-materia. Then your lordship kindly sees Article 4 there, which the Supreme Court has noticed. In credit operations, all parties concerned deal in documents and not in goods or services. This is, my lord, Article 5 in the new UCP. This corresponds with Article 5, which says banks deal with documents and not with goods. Slight modification in language, but the intent is the same. Then, my lord, kindly see, the Supreme Court says this is also declared by this court in several cases. Then kindly see 40. Article 10 refers to the duty of the bank to honor the commitment. It states as such, an irretrievable credit constitutes a definite undertaking to make payment. This, my lord, corresponds with Article Kindly give me a minute. Article 7, the undertaking.
Yes.
Issuing banks undertaking. The language is changed, my lord, but the sum and substance is the same.
Yes.
Then Article 11 is all this is set out. Then kindly come to the next page. All these articles of the bank are noticed. Then the English judgments are noticed. Paragraph 42 onwards. Now kindly turn to, my lord, paragraph 47, which is of relevance here.
Yes.
Clause D of Article 16, revision states that if the issuing bank decides to refuse, it must give notice to the bank from which it received the documents or to the beneficiary if it directly received from him. Such notice must state the documents in respect of which the issuing bank refuses the documents, and must also state whether it is holding the documents at the disposal of or in returning them to the presentor. Clause E reads as follows. Then kindly see 16E. If the issuing bank fails to act in accordance with the provisions of C and D of this article and or fails to hold the documents, the bank shall be precluded from claiming that the documents are not in accordance with the terms and conditions of the credit. Then kindly see the next. Thus, where the issuing bank does not respond within reasonable time, it cannot under UCP dispute the documents later. In that 1983 version, Mala, the period of 5 days was not there. That 5 banking days came in subsequently. But if your lordship sees the text and my lord, what the Supreme Court holds, it matches with the present Article 16. It is precluded. 16 and 17. It is 16. I'm sorry, my lord. 16. It is precluded from then saying that there is any dispute. Then can you see 48? This subclause E of Article 16 has been relied upon heavily by the learned counsel for the appellant to show that when the issuing bank expressly accepts the documents sent by the negotiating bank, no other question arises. This is also my case. He has accepted the documents. Within 5 days, he is not given a notice of demand. Now, my lord, no question arises. Then, my lord, all these, in the facts of that case, my lord, the documents were sent. Then the case of fraud was discussed. So, my lord, this judgment therefore finds at the end of it all that, kindly see 66, 64, I'm sorry.
Yes.
'65, it summarizes in the facts of that case, the plaintiff buyer had no case that the negotiating bank had any knowledge of fraud. So there was no fraud to grant an injunction. Then, for the aforesaid reasons, we allow the appeal and vacate the temporary injunction granted in favor of the plaintiff against the Bank of Maharashtra insofar as it permitted repayment. So, the appellant's contention was upheld. There is no case of fraud. Notice has not been given. Therefore, there cannot be any injunction. So, all these cases, my lord, I'm troubling your lordship with to show the importance which the courts have given to letters of credit, and, my lord, held that they are akin to beneficiaries are entitled to immediate payment. Now, my lord, coming to the facts of our case. And now kindly see, my lord, the false case made out in the opposition. Here, my lord, after these documents were sent, I told your lordship, my lord, that the buyer requested that give me the documents. I want to change the bill of lading. I want to change the details in the bill of lading. Now kindly see, my lord, the correspondence in that. Kindly come to the correspondence in that regard, which would show that they had taken the documents. Kindly see page 39, please, my lord. First of August. This is the correspondence, my lord, between me and, my lord, the shipping line. Your lordship see CMA, CGM there at the bottom of page 39. Your lordship has that, my lord. Mail at the bottom of from and it's in German, my lord. And B documentation at cmacgm.com. At the bottom of the page, my lord.
Yes, yes.
From CMA, CGM is, my lord, the shipping line. And it is writing to me, my lord, to my transporter. Kindly see subject. Re-top urgent amendment request for OBLs. OBL stand for, my lord, original bills of lading. The buyer wanted to amend the original bill of lading. Good day. Please note we have received following mail from our agent in Calcutta. Customer, my lord, who is the applicant, the buyer, has not yet surrendered the original bill of lading at our office. Please check with client. We are not allowed to amend the bill of lading as old set is not yet surrendered at CMA CGM agency. So unless you surrender the old documents, we cannot give you any new documents. Now, my lord, the documents are lying with the bank. I have given the documents under the letter of credit. Now kindly see what happens. Kindly see my response to that, which is the mail at the top of the page from DK Saraf. Your lordship sees, my lord, from DK Saraf to Eagle Trans. Dear Miriam, who's the CMA CGM, the shipping line. Indeed, unless your office have originals, you cannot make changes. I call the customer here being, my lord, the applicant, and he confirmed that CMA office must have it in hand. Can you check against with your CMA office? So customer is telling me that he is going to your office with the original bills of lading. Please check. This is what I'm saying. Now kindly turn to the previous page, 38. These are further correspondence. I'm not troubling your lordship with this. Kindly come to the mails are in reverse order, my lord. Kindly see 2nd August at page 37.
Yes.
I'm sorry, 1st August. Kindly see at the bottom. CMA CGM is writing to me, dear Saraf, BL is locked in our system. We need arrangement from port of delivery. POD, my lord, stands for port of delivery. Agent to update the BL. That means, my lord, he has surrendered the BL. On 1st of August, the buyer has taken the bill of lading from the bank and has given it to CMA CGM. CMA CGM is saying, now it is locked in our system, we will do it. Then kindly come upwards. Kindly see 2nd August now. Next day, what happens? We got a call from the customer. That is, I am writing to, my lord, CMA CGM. I got a call from the customer that he doesn't want any changes as this is taking time. Present bills of lading as it is are okay. Now, my lord, can you see next? Very important. So he will take the bills of lading back from CMA Kolkata and send it to consignee for release. We hope all goes okay now and we conclude this. Thank you for your time and cooperation. So the buyer said this is taking too long. Buyer being the applicant under the letter of credit, he said this is taking too long. Please return my documents to me, the bills of lading to me. And so I tell CMA CGM that you please release the documents to the buyer. He doesn't want any changes. Now all this is happening, my lord. Bank is not aware of this because this is correspondence between me and the buyer. Bank is not aware that I know that he has already released the document. In the month of August, bank does not know that I know. The beneficiary knows that you have already released the documents to the buyer. Bank is not aware. The buyer has perpetrated fraud on the bank. He has taken the documents from the bank, gone to take delivery. Then for whatever reason, he doesn't take delivery, returns the documents to the bank, and bank says, now I'm not going to pay you. But when the bank said, I'm not going to pay you after this date, bank did not know all this story. That I already know that he has given the documents and that 5-day period has lapsed. You have returned the documents. Now there's no question of you're not making payment. But bank did not know all this, that I always knew. Bank thought he can get away with the fraud. That the documents, I've never dealt with the documents. I'm returning the documents to you. But bank did not know of this correspondence. And the document which actually came back to me, my lord, from the bank, because when the bank refused to make payment, he returns all the documents to me. He says, take back your documents. That is what the UCP says. You must return the documents. The document, when he returns to me, has the endorsement of the bank releasing the document and the endorsement of his buyer also, which clearly proves that the bank has dealt with the documents in the meantime. Having released the documents to the buyer, now it cannot come and say that I will not make payment. This is, my lord, the fraud which the bank is perpetrating upon me. Kindly turn to the next page, my lord, at page 36. Previous page, I'm sorry, my lord. Kindly come to page 36. We receive following from Kolkata office. I'm sorry.
Yeah.
2nd August, my lord, the shipping company is writing to me. Kindly see. Good day. We receive following mail from Kolkata office. Quote, old set of original bill of lading returned to customer. So he takes back the bill of lading. Now what does he do, my lord? He takes these documents and gives it to the bank. I don't want the goods. You please return the documents. That is not what is permissible under the letter of credit. Whatever dispute he may have with me, bank cannot take the, my lord, shelter of that and say he will not pay. Bank has to pay. Now, my lord, kindly, why all this is proved to be correct? Now your lordship sees the document which comes back to me. Kindly see the document which comes back to me, along with the finally which comes back to me. Kindly come to the page 50. Kindly come to page 50. This is the, my lord, covering letter under which the documents are given.
Yes.
This is the bill of exchange which I draw. Kindly see the amount is mentioned there. Dates are mentioned there. I'm not troubling with all that. Kindly come to the bottom of that page. And kindly see the endorsement which is made there. Accepted. Accepted with discrepancies. And agreed to pay on 15 September 2018 as per swift confirmation 45 days from the date of acceptance for US dollar so much plus interest on so much, which aggregates to US dollar 170,000. Date, kindly see the date, my lord, kindly mark that it is very important. 1st August 2018. So, my lord, whatever discrepancies were there, the buyer waived the discrepancies. He wrote on the document that I'm waiving all these discrepancies. Please release the documents to me. He takes the documents from the bank on 1st of August, goes to the shipping line on 1st of August with the documents. 2nd of August, he says, I don't want it. Gives the documents back to the bank. Now the bank refuses to make payment after this. Now kindly see, my lord, the bank's refusal. Kindly come to now page, this is page number 51. I'm sorry. This is after 1st August. I'll show your lordship, my lord, what happens after 1st of August. Kindly come to 29th August at page 55.
Yes.
Your lordship has page 55.
Yes, yes.
Kindly see the date at the top. Your lordship will see run time. Run time 29th August at 15:44. So this is after 1st of August. Now kindly see what the bank, what UCO Bank is writing, my lord. Kindly see field 79 narrative. Your lordship has that. Please treat this as MT 734. Kindly make a note of this, my lord. MT 734 is of significance because in swift communication, my lord, notice of discrepancy is given under MT 734. If you raise a discrepancy on a letter of credit, you must give it in the context of MT 734 is the code. MT 734 means this is a notice of discrepancy. So he gives this, my lord, MT 734 notice on, my lord, 29th August. We observe the following discrepancy in documents received under your reference number so-and-so, resubmitted on 23rd August. So now what he says is, my lord, these documents have been resubmitted. He has to come in within 6 days, 5 days. So he makes out a false case of resubmitted on 23rd August. LC was amended to be read as so-and-so, and all these so-called discrepancy he raises. For the first time on 29th August, after his buyer has accepted the discrepancies on 1st of August. So this is, my lord, what he cannot do. Because the letter, UCP says, if you reject the documents, or you can even waive the discrepancies. So even if there were discrepancies, you should have done it within 5 days. You release the documents to the buyer on 1st of August because the buyer waived all the discrepancies. Now, after 29 days, you cannot raise discrepancy. This is the first notice, my lord, of discrepancy. But we may come back tomorrow, my lord. It's already
tomorrow.
I'm staying on a very short date, Lordship. Maybe anytime next week, Lordship. I am under some difficulty, Lordship, tomorrow. I'm praying
Mr.
for
Ghosh said he will come back tomorrow.
Lordship. I just received a notification that there might be some strike from 2 to 4, Lordship. From 2 p.m. to 4 p.m., Lordship.
Tomorrow from
Yes,
2 o'clock, my lord, there's a pen down.
Lordship, I'm praying for a very short date, maybe sometime next week, Lordship.
I will take some time to conclude, my lord. I can conclude.
Actually, I take the original side matter on Thursday.
I see, my lord. Then kindly keep it on Thursday. But if your lordship's diary permits.
এভরি করে দেবো বুধবার টুধবার দিলে হবে একটা ম্যাটার কি আবার তো হবে না হ্যাঁ many other matter has been fixed. Okay, by this time I am fixing it on 10th July. 10th July at 2 p.m.
Grateful.
10th July. And if possible, conclude on that date.
Grateful.
On that date it will be concluded. Acha. Heard the learned advocate appealing for the respective parties, leaves the matter for further consideration.
My lord, may I seek your lordship's kind leave to allow me to file a affidavit of reply against his affidavit in opposition within 2 weeks.
তাহলে 16th একটা অর্ডার করে নিন এফিডেভিট অপোজিশন আচ্ছা এফিডেভিট অপোজিশন ফাইলড অন বিহাফ অফ রেসপন্ডেন্ট নাম্বার আচ্ছা ফাইল অন বিহাফ অফ দ্য ইউনিভার্সিটি গ্র্যান্ড অফ কমিশন ছোট করে দিন ইউজিসি is taken on record. আচ্ছা stop. You are for the petitioner.
I am for the petitioner, my lord. I am filing affidavit in reply against other 2 respondents.
আচ্ছা affidavit in reply filed in respect of the affidavit in opposition
in respect of filed in respect of 1
or 2
for the state respondent, for the assembly respondent and the private respondent.
আচ্ছা affidavits in reply filed